I have a device that both has audio and visual, are there potentially any issues in recording something, both audio and visual, from the same device?
From the same device?
Correct.
There can be. In my experience, there are times when that can happen.
And describe for ladies and jury what that is, when you mean there can be some issues.
I think the most common issue we see is sometimes with certain inexpensive cameras or inexpensive surveillance cameras. In particular, you might see a slight out-of-sync audio and video. So a direct example for me might be in an interview room where you see someone speaking and then, you know, the audio of what they're saying is slightly out of sync.
And slightly out of sync's still okay, correct?
Yes, absolutely.
Because of the identifying points that you can go through and try to relink and things like that, correct?
Yes, that's correct.
And in terms of audio, you reviewed the audio here, you believe that that was seamless, correct?
Yes.
And you reviewed the video, and it's my understanding that the video is 10 frames per second, correct?
The video is actually 15 frames per second.
Okay. And so what does that mean, sir?
I'm sorry?
What does that mean, 15 frames per second?
Well, you're viewing 15 images per second of time. Standard, what you see on your television is around 30 frames per second. This is about 15 frames per second.
Okay, so that means that there is a certain amount of time in between each image, correct?
Yes, that's correct.
And so how much time is in between each image if it's 15 frames per second?
I believe 1/15 of a second.
Okay, which is 0.015,
I don't know the exact number.
okay. So, but there's always, with a video, there's always time in between each frame that the naked eye sees. You can't see, correct?
Yes, that's correct.
And so the naked eye can't pick up that time in there, correct?
That's correct.
Okay. And I noticed in some of your information, you did some study and you did I think a seminar with regards to the physics of sound, correct?
Yes, yeah, well, audio analysis and, yeah.
Yeah, and I think the exact title, it was Introduction to Forensic Audio Analysis in September of 15, Science and the Physics of Sound.
Yes, they did, yes. That was a few years ago. They did cover that, yes.
The physics of sound, sound has physics because sound bounces off things, right?
It can, yes.
And sound can be distorted, muffled, but depending on what the environment the sound waves are in, correct?
Yes, it can.
Okay. And so when you're watching on the computer the sound waves, that's what you're looking for, correct?
I'm not looking for distortions. I'm looking for what we can actually hear.
Absolutely, but you're using the sound waves from that.
Yes, that's correct.
Okay. And in this situation, you're aware that a video, you indicated was very low quality, I think you said, was on the lower end of the quality.
Yes, it is a low-quality video.
And surveillance videos, that tends to happen.
Yes, it does.
And in this situation, were you aware that you didn't get the actual video from a CD that came from the video machine or the video device that was recording it, correct?
I was given whatever Detective Shepard gave me.
Well, Detective Shepard testified to ladies and gentlemen of the jury that he couldn't get it out of that machine, so he had to actually take a video of that and copy it onto another device.
That is,
Yeah, overruled if he knows.
that is actually how we extract video from a DVR, is by copying it to another device.
So Detective Shepard had to do that first. You didn't have the actual the video, you didn't have the video machine or VCR or what have you.
No, I did not extract the video in this case.
So that gets extracted by Detective Shepard onto a device,
Yes.
and then that gets provided to the prosecutor.
I believe it came to me first.
Okay, came to you first, and that's September of 18.
Yes.
Okay, and based on that, you said, it's low quality, but I can enhance it, correct? Enlarge it.
I'm sorry?
Enlarge it, not enhance.
Enlarge it, I did brighten it a little bit, which is, I mean, it's a minor adjustment. It's not a whole lot.
And you enlarge it by the 400%.
Yes, that's correct.
But that doesn't help you see it any better, correct?
No, it doesn't. It just makes it larger for the screen for demonstrative purposes.
And different recording devices, Mr. Loomis, they're designed to pick up a higher level or more sensitive. They can be very sensitive or not so sensitive in terms of what the device picks up, correct?
Yes, that's correct.
Okay. And so one person's cell phone may be able to pick up audio better than another person's cell phone.
Yes, that's correct.
Okay.
Yeah.
And in those types of situations, again, that's a second source, correct?
Yes, that's,
And on the physics of sound, sound travels at what, 100, how fast does sound travel?
I believe it's about 750 miles per hour.
Okay, and how about light?
186,282 miles per second.
They travel at different things, and that's why the issues occur, correct?
I wouldn't say that that would necessarily pertain in this case.
I'm not saying it is. I'm not,
Okay.
I'm just asking you that two different things travel at two different speeds.
I would agree that they travel at different speeds.
Absolutely. And in this situation, if you placed a recording device in an environment and a human ear, probably not going to get the same results, correct, of what was heard, correct?
There might be a slight difference, yes.
Okay. And depending on if there's a trauma to the ear area or trauma to the human ear or other distractions to the person, individual or person, that may affect what a human hears, correct?
Yes, absolutely.
So you're not testifying in this case beyond a reasonable degree of scientific certainty that my client heard what the individual was saying while the shots were going on, correct?
Correct.
You have no opinion to that as whatsoever, correct?
That's correct.
And you watched that video, correct?
Yes,
You're not here testifying within a reasonable degree of scientific certainty that you could see anything in that video inside the car, correct?
that's correct.
You couldn't see anything of what occurred in there, correct?
You can see general movement.
Basic movement, and no specifics, correct?
Correct.
And you're not here to testify in any reasonable degree of scientific certainty about what facts occurred and when they occurred, because you don't know the facts, correct?
That is not my lane of experience, no.
Okay, you weren't provided with any of that information, correct?
That's correct.
You were asked to take one thing, take another, and try to sync it up. Try to enlarge one thing, try to sync it up, correct?
Yes, that's correct.
And you did the best job that you could, correct?
Yes, absolutely.
Okay, may I have a moment, Your Honor? Mr. Loomis, thank you again for your service and thank you for your testimony.
Thank you.
Any redirect? All right, Mr. Lewis, step down. Leave everything else up there, yeah, just leave it up there. Councilwoman approach. Off the record. Yeah. Any further witnesses on behalf of the state?
The State Union Board.
Is all doing all right? Make it to lunch? All right.
We approach, Judge.
as I was telling the lawyers, they whisper over here, and you guys can't hear it. I'm like, just talk normally. Sir, if you want to come around, this is a little maze. You're even got a seat number right over here. See, I told you I need to get that yellow tape on the ground.
Yellow Brick Road.
Raise your right hand. You solemnly swear affirm under penalty of perjury your testimony in this case will be the truth, the whole truth, and nothing but the truth?
I do, sir.
Have a seat. Point yourself up close to the microphone. And you may inquire.
Thank you, Your Honor. Would you please introduce yourself to the jury and tell them what you do?
Good morning. My name is Jamie Borden. I'm a retired sergeant from the Henderson Police Department out of the Las Vegas area, Nevada. Currently lecturing and doing consultant work in law enforcement.
Let's start kind of at the beginning of your history. You were a law enforcement officer
That's correct.
for how many years?
I was a law enforcement officer. I've been post-certified since 1997 with a small break in between. Still currently post-certified, however, retired and happy about that. And would you, counsel, would you like me to go into what I did at the department?
Please let us know what your duties and your positions were within the department.
Started out in patrol. I worked patrol for a good while, became a field training officer, then promoted into the Detective Bureau, where I was narcotics officer, vice officer for a short time. Took a break, then I came back and was back in patrol for a period of time, then promoted into the Training Bureau with OIC. I promoted into the Training Bureau as an officer in charge and became eventually the commander over that unit as a sergeant. I was in charge of all training for the entire department, a department of approximately 500 at the time, and was primarily responsible for the development of the use of force training and analysis unit, which was the investigative entity that looked at all use of force on the department. I held that position until I retired in 2018. I was also a sergeant over patrol squads in a relief capacity, staying involved in the patrol environment as a supervisor. And I did that from approximately 2011 until 2018 when I finally retired.
And then what did you do upon retirement?
Before I retired, I'd started a company, my own company called Critical Incident Review, and I was doing consultant work for departments around the country, and had also been very immersed in human factors education, subject matter regarding human performance, police performance, training, things of that nature. I was certified by an entity called the Force Science Institute. They are responsible for conducting research on human factors, human error, decision-making, things of that nature. I was certified with them. Then I became the first advanced specialist under their umbrella, and they hired me to lecture for them in 2013 while I was still employed. I was a senior lead instructor for them for about 9 years, lecturing all over the country in human performance, police performance, decision-making, all in critical incident, biomechanics, and the things that happen to the human body under critical stress, and teaching that to departments all over the country, municipalities, sheriff's departments, FBI, the DEA, the DOJ, all the three-letter acronyms, Homeland Security. And I did that up until 2019 when I began teaching under my own company's umbrella, where I have my own certification course now. It's called the Enhanced Force Investigation course. I also have expertise in video review and examination, so I do that as a consultant. I also teach that, and that brings us to where we're at today, at this point.
You talked about having these various trainings, force science, things like that. Are these, I guess, agencies, or are these some sort of offerings that are available nationwide?
Yes, so the company, the Force Science Institute, my company, offer trainings to departments nationwide. With the Force Science Institute, I believe I had my hands on about 12,000 officers in this country, from Anchorage, Alaska, all the way to Delaware. I've taught in all 50 states. And my company, which is a little bit newer now, I've had classes in probably 10 states and had my hands on approximately 5,000 to 7,000 officers nationwide.
And what do you mean when you have your hands on them? Are you training them? Are you observing what you're doing?
So, yeah, hands-on. I'm lecturing and training, providing training for officers in the realm of use of force decision-making, investigations, everything that ties in. Our students are law enforcement officers primarily. I also teach attorneys, psychologists, anyone who's engaged in law enforcement who is looking to understand the human factor aspect of decision-making under critical stress.
And you've mentioned Force Science and the Force Science Institute. Is this more of a scientific study? You're using things like performance and words like that. Please explain.
Yeah, it's scientific principles that have been studied, and empirical data exists that talks about human performance. How long does it take us to perceive something? How much can we focus on at one time? Different things of that nature. And a lot of it has to do with human performance in terms of timing. How much can we accomplish in what amount of time? What can we perceive, and how long does it take us to perceive it? What do we identify as truth and what is actually fact because of the way the cognitive systems work in our brain? All of that related to law enforcement has a basic scientific foundation, and that's what I teach.
And is a lot of that based on just observation of officer decision-making under either maybe controlled or actual circumstances?
Are you referring to the studies, the empirical data?
Yes.
Yeah, so the studies are not a response to a threat, bang, 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 until the threat stops or change in behavior. It's a much different cadence. It's a much slower and deliberative process, and that was one of the things that I looked at in this case primarily.
And does that analysis change, or is that cadence expected to be slower if an officer is using a non-dominant hand? We'll start there.
So not necessarily. There's in the process of responding rapidly to a threat, it can be slower. And remember, that 1/4 of a second per round fired is empirical data that comes from a sterile laboratory experiment, right? So that's a baseline that we use to begin with. My experience in handling cases, that's still the average. It's still very close, between 16 and 3/10 of a second, 160 milliseconds and 300 milliseconds. So it's still very rapid. And even if there's a pause in between volleys of rounds, the volley of rounds is one decision to shoot, to then look for a change in behavior. And that's the common structure that I use when I'm analyzing these cases. And when I see something like this, I have to start kind of digging deeper into the why this is happening in this particular case, when statements say a particular thing or evidence points towards a particular thing. Right hand, left hand dominance doesn't have a lot of effect on it. One of the fastest cadences I have on record in my cases that I've consulted on and reviewed is around 160 milliseconds with the non-dominant hand. So it can vary, and it does vary, but it's slight within that window.
And what about if somebody's firing with an injured hand? Is that expected to have these gaps in the cadence?
Counselor, when you say these gaps, are we talking about this case specifically?
Yeah, I'm sorry. When you're seeing the sort of gaps that you saw here, 6 shots over 12 seconds with those pauses you mentioned, if a person is firing while injured, would you expect to see these gaps? Would that account for these gaps in some fashion?
In some cases, it could, and that's what I would end up looking for in a case like this, where we have an extended gap in between an extended interval, I should say. One thing I would look for is statements to say that I was disabled for some reason, and that's not the evidence that I found in this particular case. There was no evidence that that was a prohibitive factor, considering the time between these shots fired.
So you mentioned these pauses, and I think you used the word assessing or reassessing. Explain to the jury what you mean when you're saying that there's this assessment needed.
So in law enforcement, a use of deadly force is it's not something we can use as a blanket shield, if you will, against a deadly attack, because circumstances change. When an officer is using deadly force, what is looked at is there time to assess? Has an assessment been done? Is the officer looking for a change in behavior or a cessation in the threat to now stop pulling the trigger, which takes time as well. Everything that we do, everything we start takes time to stop. So those are also considerations in these analyses. In this particular case, the cadence that we're hearing is not indicative of a decision to shoot and have a volley of rounds and then an assessment period. It's different than that, and if I get the opportunity, I'll get into that later. But what we're seeing here, and what's important is to understand, is that officers must assess during a use of deadly force. That use of deadly force has got to stop as soon as there is a perceivable change in behavior in the circumstances, in the subject, or the totality of the facts and circumstances that they're engaged in that moment. I hope I didn't lose anybody. It kind of felt like I was talking in circles. Counselor?
And maybe we'll come back to that as we actually go through the timeline here, so that I'm not confusing anybody. let's step aside for a minute from the cadence and how that influenced your opinion. And I want you to explain for us what other factors you considered important in your analysis when you were reviewing this for reasonableness.
So the factors that are important to me are, the way I look at these cases is I look at the actual event. In my primary or my initial analysis, I'm not looking for should've, would've, or could've. Backwards looking language, right? Where I'm looking at what could have happened or what should have happened or what may have happened if. I have to look at the actual event as it occurred. So I'm looking at the factors in the case from both sides of the fence, not just the officer involved, because we run into a number of biases, and I'm sure you've heard that word a lot lately in whatever it is that you do. But biases are very important to understand that exist. They exist in what we do, each and every one of us. And if we don't take steps to navigate those biases, we can make mistakes. And so what I do is I look at the factors of what actually happened. And if that information is supported with data or statements from the involved, then we have a supporting objective standard. If it doesn't exist, I have to now dig deeper because I'm conducting an analysis and a review, or a review and an analysis of this case. And now if things don't align, I have to now figure out why that doesn't align.
Right? Did you consider in this case, first of all, the fact that there's a motor vehicle involved in the way it was parked?
Yes.
Okay. How, if at all, was it important the way that the vehicle was parked against the building?
So that's, in undercover work, that's considered a good tactic. It prevents potential escape. When you're working in an undercover capacity, how you position a vehicle and how you look forward through this event, looking at it in worst case potential scenarios, it's best to have containment. And that way, with containment, which is an awesome tactic, it's a great way to think, with containment, it gives you additional options should things go upside down. And it happens. When officers are dealing with, and I say we sometimes because I've been a cop for so long, I'm retired now, my blood still runs blue, so forgive me, I am retired, but I might say we sometimes. Officers working in that capacity are working with dangerous people. They're enforcing laws with potential criminals. And so parking the vehicle in a place where someone is contained is very important. And that was something I looked at in this case.
Were there any other tactics that became important in your analysis, whether good or bad?
Another good tactic was having the child locks on the back doors of the vehicle engaged, so that should there have been attempted escape, the person is contained inside. Those are all great tactics. The opening of the door when things turned upside down, it's a great tactic. That is, when we're using a deadly use of force, we're implementing a deadly use of force, we need to be able to maneuver. We need to be able to establish parameters that we can maneuver, and that's not to say that the officer is going to retreat, but if we can make distance with barriers, considering time and space, to give us that little bit of extra time to make a decision, because use of force, again, is it's a decision that should sting when we use force, especially deadly force against a citizen. So all of those tactics seemed that they were implemented properly in this initial contact.
And on the flip side, did you find any tactics that weighed on the other side?
Yeah, and so everything that led up to all of those tactics, potential containment, the vehicle door was never used as an escape route. It was never used to step outside of the vehicle to create that distance and time that we can stand out, even if we have to cover with deadly force. We are still able to assess that very important component of taking those seconds to assess a change in behavior, to assess the fact that there may or may not be a weapon in play, because those are things that literally they can't be known in the heat of this moment. What officers are trained to do and expected to do is to look for a place to create some sort of time and space and distance to assess, if safe and feasible to do so. All of the tactics that led up to that allowed that safe maneuver out of the vehicle to assess.
So if a person has already been injured or attacked in some fashion, is an officer safe to assume that another attack is forthcoming?
That's a great question. And again, this is a case-by-case scenario. When an officer has been attacked, and this is where we have to look at both sides of the fence, the officer's perceptions, what is the officer dealing with in that moment? Regardless of what our opinions are on the other side, right? But we still have to consider both sides of the fence. The officer, in this case, is cut. That is a potential deadly attack. And yes, you can, in those moments, especially the moments preceding and following the decision to use deadly force, we have to be analyzing the fact that I'm under attack. Is this going to continue? That's absolutely part of the thought process.
And what sorts of things do you look at to decide, is an officer under attack, or is an officer maybe in a position where he is attacking?
Counselor, can you rephrase that question for me? I'm sorry.
That was a terrible question, I'm sorry. You've mentioned when an officer is under attack, and I think I started it with saying, just because an officer's been attacked or cut or threatened at one point, do you get to continue that throughout the duration, continue that subjective belief throughout the duration of an event? Going from that premise, we're looking at the subjective belief of the officer at the time, correct?
Correct.
And just because an officer has been attacked, is an officer then entitled to presume that he is going to be continued to be attacked?
The presumption can exist in that, and I hope you understand the question. I think I understand where the question is going. The presumption can exist, and every step taken from that point forward should be made with the presumption that there's going to be a continued attack. Now, whether there is a continued spontaneous attack is the question. And when we look at this and we identify that, the fact is that that didn't happen, right? And there's one other component to this, is that we're looking at this under the color of law. But one of the issues that I'm looking at in the subject matter that we're talking about here is that there's a very high potential that Donna didn't believe that this was a police officer. There was no discernible markings, and we're talking about a criminal activity in a criminal environment where criminal things happen. So there's trust issues. I know this. I did the job. There are trust issues with the people that we deal with from a law enforcement side. And one of the sides that I looked at in this, and one of the questions I ask in nearly every use of force case, is, was the officer identifiable clearly as a police officer? Because that's going to affect what's happening on the other side of the fence. And that can't be ignored, or it's not an objective review. Not talking about an objective standard, but an objective review. I have to consider the fact that the other person involved in this incident did not believe that there was a police officer in the car with her. And the evidence, this isn't my assumptions, this is what I gather from the evidence, is that this person believed that they were going to be harmed. They believed that they needed the police. And all of that is very evident in the audio evidence. And I can't ignore that. I can't ignore that at face value. So what I'm looking at is a police officer that's been injured, who the other person doesn't know is a police officer. Is that a defensive wound from the person that's dealing with the police officer? Is the police officer responsible for the escalation of this force simply by trying to control this person without this person believing it's a police officer? Those are all aspects that I have to look at in an objective and balanced analysis of this use of force.
So in looking at this, you said you have to consider whether or not, first of all, it's important to know whether or not she believed he was a police officer.
Yes.
And in looking at what you reviewed here, you believed that that was problematic,
Yes.
based upon your experience working undercover as well as all of your cases that you handled.
Correct.
In light of that, is there an expectation that a reasonable officer should behave in a certain way with what had transpired, with the "I don't believe you" and options available to the officer?
Yes, and this goes, and again, I have to clarify what's happening here, because I'm giving an opinion on a case because I've been asked to give an opinion. It's an objective analysis with an opinion. When the evidence doesn't match, the subjective evidence doesn't support the objective standard, and I identify that, I then have to start digging deeper and figure out why this isn't happening. So this sounds like reverse language. The officer should have, would have, or could have. Well, I have to get to that point because I'm not getting supportive subjective evidence to support the objective standard through Graham. Is everybody tracking with me on that? So I now have to look at why. And we have someone who's not clearly identifiable as a police officer with no contingent plan available. There's no backup, there's no badge, there's nothing to say that this is officially what I'm doing and you are officially under arrest. That never happened in this case. So part of my analysis is, why doesn't this meet the objective standard in my initial analysis? And that's the information I look at. In a situation where we're dealing with a known criminal that is more than likely under the influence of some sort of controlled substance, it happens very common. It's very common for it to happen, I should say. These are all things that cause police officers to do things in a particular fashion to give options in the case of a critical incident. And those things weren't in place on this particular matter.
So is the fact that Mr. Mitchell decided to go hands-on and cuff her after expressing a disbelief part of your factors and analysis here?
Yes.
And in considering that action, did you find that to be a good tactic?
I didn't find that to be a good tactic. I was the commander of a training bureau, and I was responsible for training officers for much of my career, about half of it. The issue I've got with it is that we trained, and every department I've ever trained, and I've trained departments across this country to the tune of thousands of people. When we're dealing with a human being that we have no knowledge of, their skill set, what weapons they might have, if they're under the influence of drugs or alcohol or any of those other things, places us and them in a very precarious position if we choose to go hands-on without other resources available. Sometimes we have no choice, but when we do have time and it's safe to do so, everything should be pulled back, and there should be other resources brought in, whether it's to prove that you're actually an officer or there's backup nearby. These are things that in our particular jurisdiction, which I know isn't Columbus, we would discipline officers for going hands-on with people without a backup because of the nature of the danger that exists. We just can't predict unpredictability. A human being is one of the most unpredictable animals on this earth because they hold intent, they can make a plan, and they can act on that plan before you can react to it. And those are all reasons that these tactics are so vehemently important to have safety, for the safety of the officer and the safety of the suspects that we're dealing with.
One of the Graham factors and one of the issues here is whether or not Donna's perceived as resisting arrest. Would you agree that's been a topic?
Yes.
In considering whether or not she's resisting arrest, I mean, why is that important to decide? It's a gram factor if the suspect is resisting arrest or fleeing. Why is that an important factor, and is that in play here?
We are dealing with a police officer, and we are dealing with someone that this police officer had probable cause to conduct arrest on. But we're dealing with a trust issue between these two. So in terms of the gram factor of resisting arrest, we have someone who doesn't believe that they're actually under arrest, who is defending themselves against what they believe to be foul play. But we have an officer that knows inherently that he is a police officer conducting police business as a police officer. And you can see the collision of trust and issues that arise that ended up in the outcome that this case did. And so it's a very important aspect to me. We've got to be able to bridge that gap, and steps have to be taken. Police officers are expected to and required to assess and take steps to do things safely, to do things appropriately. We have authority. Police officers have authority. They have the right to use deadly force. That's a right. They have a right to commit homicide as a police officer, as a sworn police officer. But that comes with a very, very high requirement. It comes with a high expectation that officers are going to take every step to make sure that that deadly use of force, based on their reasonable perceptions that have to be supported with subjective evidence and objective evidence, that they've taken steps to make sure that that use of deadly force was the only and last resort they had to save their own lives or the lives of others.
So in reviewing the behavior of Donna Castleberry, you said that's important in this case. You looked at the video and audio, correct?
That's correct.
And in doing so, would you say that Donna was resisting arrest?
Looking at both sides of the table, I believe that the officer felt she was resisting arrest, and I believe she felt like she was going to be harmed, and she was not resisting arrest, but defending herself. And that's the complication that we're facing here. We have her perspective of not believing and not trusting, and another perspective of, I'm a police officer, you're under arrest. So I have to give merit to both sides, and I think I said that, and I don't want to beat a dead horse. But in that case, and if I were looking at this for, say, another perspective, let's just say a domestic violence where two people were involved, I would have one person that's a primary physical aggressor, and I would have one person that is defensive. And in this case, I believe that Donna was defensive. I believe that her actions were defensive. I believe that the cut was defensive. I believe that the leg to the throat. We don't choke people with our hands or with our feet. We choke people with our hands. That's a human nature issue. The foot against the throat aspect is someone kicking someone away, attempting to escape. That's a defensive move, and I have to look at that. I have to look at that aspect of this event to do a balanced analysis.
So you're telling this jury, your review, you believe that Donna's actions were defensive throughout this. Would that be accurate?
I would say yes, primarily. They were defensive. From her perspective, they were defensive.
And you've said the cut, how can you call a cut defensive here?
Well, I mean, it's the position of the cut. It's across the hand. And it's an injury, and there's no refuting that. It's a bad injury. We have a subject that's, we have an officer that's taking someone into custody, and someone saying, don't touch me, where this knife comes out and the slice goes across the hand. It's not a stab. It's not an offensive type of move. And this comes from investigating multiple other crimes where violence was imparted on another human being. And my purview of this is that I've got to look at the perspectives of both parties, and those appear to me to be defensive by nature, just based on the decisions that were made to take this person into custody, to put them in handcuffs, in confined quarters, without knowledge of an exit plan, or without, I should say not knowledge, but without using that exit plan once things turned upside down.
You said kicking with a foot, kicking away is defensive, correct?
I believe in this case that could be determined as defensive, yes.
What about movement throughout the vehicle? Did you find the movement throughout the vehicle to be defensive?
So the video, if you've seen the video doesn't show a lot. It's very, very blurry, and you kind of see a mass moving around, and you see it moving back and forth. We're in very close proximity here still. And again, two perspectives. We're in very close proximity, but what I see is someone moving back and forth across a seat while there's audible evidence yelling for help from the police. So in essence, I would say from her perspective that's an attempt to escape. It's an attempt to escape and an attempt to defend at that point.
And when you say escape, you mean get away from this person she's saying get off of me from?
Yes.
We, let me go ahead and do this for a minute. We talk about, and I apologize, I'm jumping around a little bit here, and I'll try to get back on track a little bit once we go through the timeline. The verbal cues by Donna Castleberry, would those be important as an officer to be assessing whether or not somebody is a threat?
Of course they would be. But here's the issue, is that with verbal cues that we hear on the recording, that's part of my assessment. That's part of my analysis. I can tell you that they're audible. You can hear them in analysis. But I can't say definitively that the officer involved heard them. I can't be in the officer's head and say that you should have heard those, right? We can't say that because I don't know what the officer's focus of attention was at that moment. I can tell you what the evidence reflects. I can tell you what the statements say. I can tell you how those two things align. But I can't be in an officer's head and say that those were heard. Now, the caveat to that, if you don't mind if I carry on, one of the caveats to that is, as human beings, if we're suffering auditory exclusion because, say, gunshots are being fired, which were in this case, and we don't hear the more finite level of recording that you've heard on the audio recording, the officer may not have heard that. But I will tell you that at that point, our focus of attention is on something either tactile or visual. And that's the way the human mind works, right? We focus on what's most important in the moment. And in this case, where deadly force is about to be used, if there's visual focus happening, that visual focus needs to be on identifying a change in behavior or a continued spontaneous attack. A continued spontaneous attack from this person, because we, in this position where the officer's been injured and there is a supposition that it's going to continue, then you need to be figuring it out, right? But there are other issues that have to be considered. If that's the fact, and there's time available, extricate into a safe position to cover, to give commands, to create communication, contain, communicate. Those are all important aspects of what an officer's assessment can drive them into doing in terms of making a decision tactically in a case like this.
So would you characterize, you've mentioned spontaneous continuous attack. Would you characterize the actions by Donna Castleberry a spontaneous continuous attack here?
So the first time that the officer is cut, it may be perceived as defensive from Donna's side. From the officer's side, that may appear to be a spontaneous attack. And that's irrefutable, right? There's an injury. One human being has attacked another. A continued spontaneous attack with somebody with a weapon is somebody who is continuing to attempt to kill you, to make a deadly use of force reasonable in this case. And that's what I'm looking at in my analysis. And the language gets tense when we talk about this. But when I don't get an alignment of the subjective evidence that's available, the statements that align with video and what the end result is, and I have to dig deeper into the analysis and figure out why that's happening. This is the difference between judgment and an analysis and opinion of a use of force case. Please understand that.
So once Donna cuts Mitchell, does that give him carte blanche opportunity to shoot her?
The answer is no. As an example, and this is an example that use of force experts use around the country, if an officer comes around the corner and he contacts an individual, and that individual matches the description of a bank robber who's just killed a teller, and that subject reaches into his waistband and pulls out a weapon and fires a round at that officer, throws the gun down and raises his hands before the officer can draw the weapon, the officer is not going to be using reasonable force if he continues through with shooting that suspect. And that's part of the risk that has to be considered in law enforcement. It's not carte blanche, even if an officer is injured. And this isn't my presumption. This is cases that I've worked on in the past. We can't assume that because there's been a deadly attack or a perceived deadly attack, that it's carte blanche to stop that person. The idea is to stop the threat. To stop a threat, the threat has to be ongoing. We have to assess and analyze the fact that these are the statements that are being made. Was there an actual ongoing spontaneous attack that warranted deadly force in this scenario?
And in this case, did you find an ongoing spontaneous attack by Donna Castleberry?
The evidence doesn't support an ongoing spontaneous attack. Counselor, can I expand on that?
Yes, please, if you need to.
When I talked about the timeline and I talked about the intervals and the things that were happening, from the time the event starts to turn sideways, there's over 40 seconds. In that time, things were happening. In that time, Donna was kicking away with her foot. The officer has been injured. What's looked at here is the factual outcome. A seatbelt has been removed. A weapon has been extracted, pulled from the holster, the door opened, and then shots fired. There's a long time. There's a long stretch of time, a very long stretch of time in terms of a critical incident. Critical mass, decision-making processes, a very long time. And in that time, there was no further injury inflicted by that knife or any other knife. If it was going to happen, it would have. At that point, it would have taken approximately the same amount of time to step out of that vehicle and assess and cover, to look for a change in behavior, as it would have to do anything else. And those are the things that I had to look at concerning this timeline.
Let's go through your timeline a little bit. I'm going to show you, marked as State's Exhibit J1. I'm going to need heart, please.
Let's approach. still whispered sidebar. What?
Thank you, Your Honor. All right, Mr. Borden. State's Exhibit J1, hopefully you could see this, is listed as timeline and transcription derived from encoded audio stream, and then underneath, there's a portion, significant increments of time and intervals between occurrences. Do you recognize this information?
Yes, I do, Counselor.
And what does this represent?
It's the timeline from the recorded data from this, I believe from the cell phone data that recorded this incident.
Did you go through the tape and make this timeline?
I did.
And what was the importance and significance of you doing so?
As I said earlier, it's just, this is one of the things in a use of force case that is one of the primary components that I look at, is the time that this entire thing took to happen and the time between important points. The notification that he sees a knife, the notification that he's been cut, the time that elapses between that time, which is a spontaneous deadly attack from the perspective of the officer. How much time is passing by at that point before the onset of, or the initiation of deadly force? So this timeline is very important for that purpose.
And then you break it down further into the significant increments. Why is this increment, this portion here, most significant?
It just outlines the things that I looked at: the total event duration, the statement that the officer makes. I don't need to repeat it; you can read it. And then the intervals. The statement that she's got a knife to the first shot fired is nearly 47 seconds, which is a long stretch of time. And I understand that there's other dynamic issues going on at that time. But we have to understand that during that time, there's a point where I know that a weapon was withdrawn, a seatbelt was taken off, and deadly force was implemented. And all of that takes time. So we look at the time she's got a knife, and then the total time to fire the 6 rounds in this case is 12.850 seconds. With the intervals listed here, the intervals they represent a deliberative action. They don't represent, in any case that I've handled up to date, they don't represent someone shooting to save their own life rapidly based on a spontaneous, continuing deadly attack.
I'll leave that up for just a moment. Did you also prepare a report in this matter of which that is a piece of?
Yes, ma'am.
I'm gonna, if I may approach, Your Honor.
You may?
State's Exhibit I-3.
With the light on?
What is that document?
This is the second report that I was requested to do a analysis of this use of force.
And that was the report you prepared and presented to us regarding your findings in this matter, correct?
Correct.
Are you familiar with the name Kevin Davis?
I am, yes.
Who is Mr. Davis?
Kevin Davis is also an expert, I believe, and he's got a couple of books out, and I believe I'm not sure if he's retired yet or not, but I know he's an expert witness and consultant in use of force.
And has he attended any of your seminars or trainings?
He has.
Have you reviewed Mr. Davis's report in this matter?
I have looked at his report.
And do you take issue with his report?
This is always tough for me because we're all got a role, purpose, and function in this. And I will tell you that I don't necessarily agree with some of the opinions that Kevin Davis has in his report. They're not the same as my opinions, I would say.
And do you believe there's some reasoning that is not sound or based in law?
Well, so I'm going to jump to the point. Some of the stuff that I read isn't substantively supported with evidence in the case. There's some assumptions, and that happens a lot in reports. There's assumptions that occur. And one of the other issues that I have with the report is that there's not a lot of consideration given to the change in circumstances and the evidence that supports the change in those circumstances. Understanding that we're looking at an officer's use of force, but there's another side to that had this particular outcome. So those were the things that I looked at mostly in that report, and I didn't spend a lot of time on the report. It came out I received that after my report had already been finished. But those are the things that I looked at, is that there's got to be a factual basis for something to be part of a report in an analysis. One of the statements that sticks out to me is that the officer lost consciousness, and there's no evidence of that anywhere. There's no evidence that I've read that the officer lost consciousness ever in this. I've heard that there was a close feeling of losing consciousness, things of that nature, but never an actual loss of consciousness. That's not a fact that's supported with any substantive information. And then not identifying the fact that there's a continual deadly threat happening because someone is still in an agitated state or moving or struggling. None of those, agitated state, moving, or struggling, none of those are a description of a deadly attack. They're a description of something very different. And so in my analysis, I need to know why. And we know that there's things going on in this car. We understand that. We can see movement, generally speaking, and we can hear the audio recording. In an analysis of this, I know that these things are happening, personally. They can be a part of my analysis, but I can't assume that anyone else knows that, if that makes sense.
We've been hearing terms like shoot until the threat is stopped. What does that mean? Please tell the jury.
I'm not going to beat a dead horse on this. We've talked about it quite a bit. We have to assess. We have to continually, police officers have to be in a constant state of assessment in the course of using deadly force because we're looking for a change in behavior. An officer who is applying deadly force is looking for a cessation in the threat. When that cessation is realized, perceived, and the officer has controlled that scene, then that is basically stopping the threat. But there has to be a valid threat occurring. There's got to be a deadly attack for that threat to be quelled with deadly force. There's got to be something going on. Now, there are cases where officers, and you've all heard them, there's cases where officers have fired their weapons at somebody that was unarmed. You've heard this in the news. And the officers were exonerated from any wrongdoing and found to be reasonable in the use of force. An officer doesn't have to be right, they have to be reasonable. But that is happening under a very extreme compression of time, where an officer is responding to someone who contextually had a weapon, and that person goes under the pants and comes up, and the officer responds with deadly force. And that person turns out to be unarmed. The officer was wrong, but the officer was reasonable based on the context of what's happening. That perception was reasonable based on the context that the officer was dealing with that potential deadly threat. And that happens more times than I'd like to say, but it does happen.
So based upon your review of the materials, What is your opinion as to whether the use of force here was reasonable under the prevailing national standards?
Based on everything I know, the evidence that I've looked at, my review and analysis up to identifying the objective standard and the lack of evidence that supports statements and things of that nature, my opinion is that this use of force is not reasonable.
And I know we don't want to beat a dead horse, but if you would just highlight again, what were the important factors, I think you've already mentioned cadence, that allowed you to come to that opinion?
What guided my decision in this is the simple fact that the increments of time that existed where assessment could have happened. The evidence showing that there was no continued attack. There was no continued attack happening, and the failure to note the change in circumstances and facts that were being faced in real time by the officer.
Thank you very much.
Any cross-examination?
May I proceed, John?
You may.
Thank you very much. Good afternoon, sir.
Good afternoon.
We met earlier.
Nice to meet you again.
My name is Mark Collins, along with my co-counsel and partner, Ms. Stevens. We represent Andy Mitchell. I want to go over some basics with you and talk about legal concepts, case law, specifics of your report, okay?
Yes, sir.
One thing I noticed on your report, because I've seen some of your other reports, you have that in front of you, correct?
Yes, sir.
You have an incident date of January 15th, 2019 on your report.
Yes,
The incident here was August 23rd, 2018.
that is a typo.
That's a typo.
Yes.
Ms. Pritchard asked you some questions on direct early on, sir, about when were you actually retained and engaged to review this case by the prosecution?
I believe it was early 2020.
Okay, very good. Something you said earlier, sir, Mr. Borden, is Ms. Pritchard was asking about whether or not you take a case or something like that. And you gave the ladies and gentlemen of the jury an example of, hey, if a prosecuting, you said a state attorney calls and says, hey, we've already charged this person, we want you to do a report based on facts, you said no, because they predetermined the course, correct?
Well, yeah, so let me refine that answer if I might, or do you have more?
Let me, because I wasn't sure what you said, so I got a copy of it from the court reporter.
Okay.
If I might read it to you. The question was, if someone were to ask you to take their case wanting to come to a certain opinion and have to say what I can do that, you said, yes, I have. Occasionally, I will get a case where the case has been predetermined. For instance, I will receive a call from the state's attorney office or something and say, hey, we got this case, we are indicting the officer, and here are the facts of the case. We need you to do a report. You said, well, hold on. If you've already made up your mind on this path, then my services aren't required. You said that to ladies and gentlemen of the jury, correct?
Correct.
You realize that the incident date here is August 23rd of 2018, correct?
Yes.
Do you realize that he was indicted on April 4th of 2019, correct?
I'm not sure the indictment date. I'm going to take your word for it.
So April 4th of 2019. So you prepared a report in June of 2020, correct?
Correct.
You were retained until sometime later in 2020, correct?
I'm not exactly sure the dates, Counselor.
You just told the ladies and gentlemen of the jury you weren't retained until 2020, correct?
Correct.
So you did, in this case, exactly what you told the ladies and gentlemen of the jury you don't do because the case has already been predetermined. An indictment means that the prosecution has already predetermined a path, correct?
Correct.
And Ms. Pritchard was part of the team that indicted this case, correct?
That's correct.
And she's the person that reached out to you, correct?
That's correct.
So exactly what you told the ladies and gentlemen of the jury about how you pick cases and how you do cases, you violated that in this situation, correct?
No, I did not.
Yes or no, you were asked to do your services after this case was indicted and they chose to indict. Yes or no, sir?
That's yes, but I have a caveat to that.
You can explain your caveats to Ms. Pritchard later on, okay? With all due respect, okay? Now, you also talked about, you reviewed Mr. Loomis's work, correct?
I did.
You're not certified as a LEVA person, correct?
No, I'm not.
You actually, he has more credentials in that area than you do, correct?
In Actual technical video analysis, yes, not video review and examination.
Right, so you don't have even the credential state, but you somehow told the ladies and gentlemen that you, of the jury, that you reviewed his work and found it to be okay?
Yes,
Okay. Normally, it's someone with more credentials says that the work's okay, right? Not someone with less credentials. Is that a fair statement?
no,
Okay, so you're comfortable with people with less credentials reviewing someone's work and then saying whether or not they agree with it?
correct. Credentials don't necessarily mean experience in
How
the
about
craft.
certification?
Certification doesn't mean more credibility in the craft. That's a particular,
Are you saying that you have more credibility than Mr. Loomis in this situation, sir?
in this situation, I was retained.
Yes or no, sir?
Yes, in this situation, I was retained because of my experience in video.
The question was, do you believe you have more certification and credibility, or issues and experience with videos than Mr. Loomis?
Yes.
Your answer is yes.
Yes.
Okay. I'll be sure to inform Mr. Loomis of that.
Objection, Your Honor.
Ask the question.
Ms. Pritchard,
Just
As to the comment.
As to his comment.
Ms. Pritchard indicated that you had been retained in this. You had been retained, correct? Tell the ladies and gentlemen of the jury what your upfront fee is to review a case.
In this case, I charged an 18-hour retainer at about $275 an hour, so my fee is about $4,950 for the review and analysis of this case.
And to prepare a report, what do you charge?
That's all part of it.
To come and testify, what do you charge?
Nothing.
Okay, zero. How about for flights?
They cover the flights.
Room and board?
They cover that as
So
well.
all of that is included by them, correct?
Yes.
Now, you try to keep up with case law in these types of cases, correct?
I do my best.
And you're familiar with Mr. Patrick's book, correct?
I am.
I think we have it here, In Defense of Others, correct?
Defense of self and others.
Yes, I'm sorry.
Yep.
In Defense of Self and Others.
Correct.
And in that situation, you've actually used concepts in there to train with, correct?
I have.
You've also used case studies to train with, correct?
I have.
You've used case studies that your offices or your old department's been involved in, correct?
Correct.
And you try to use those types of treatises to improve on the training of law enforcement.
That's correct.
Okay. And you told Ms. Pritchard earlier that, yes, Graham and his progeny kind of give the national standard, correct?
That's correct.
And you're aware that in Ohio, it's the state v. White that interprets Graham for the state of Ohio.
I am.
Have you testified in Ohio before?
No, I have not.
Okay. Are you familiar with state v. White?
I am familiar with it, but not intimately. There's a
Okay.
lot of case law out there, and I've heard of it, but I'm not intimately familiar.
Would you agree with me that's the eminent case that interprets Graham v. Connor for the state of Ohio?
Yes, with that specific case fact pattern, yes.
Absolutely. And we, in fact, sent that to you yesterday, correct? Because we didn't know if, in fact, you had reviewed it.
Yeah, and unfortunately, I didn't have time to open that, but I do appreciate that.
Okay. You didn't have time last night?
I did not.
You didn't have time this morning?
No, sir.
Okay. So you chose not to review it.
Didn't have time.
Okay. How long does it take you to read a case, would you say?
To read and understand a case, for me, 3 to 4 hours.
Okay. So you didn't have that. And you've been in town for 3 days, correct?
I've been in town since Tuesday, correct?
And you realize you're testifying in Ohio, so you didn't take the effort to go and say, hey, what's the seminal case in Ohio that interprets Graham v. Connor? You chose not to do that, correct?
I did specifically because the fact patterns are different in that case. Still a use of force, but there's a vehemently different fact pattern.
So are you saying State v. White isn't the interpretation of Graham v. Connor for Ohio?
In that case, it is.
Okay. Now, Graham and its progeny set forth legal parameters which kind of act as guardrails, correct?
Correct.
It acts like guardrails in the analysis, correct?
Correct.
Okay. And the guardrails are for individuals like you who are experts, correct?
Yes and no.
Also for law enforcement?
No, can I answer your question, or is this,
It's a poorly worded question. I'll get to it.
okay,
You're very familiar with Graham v. Connor.
I am.
And in Graham v. Connor, there are some factors that are laid out, correct?
Correct.
Okay. And there's specific verbiage that is used, correct?
That's correct.
In Graham v. Connor, words mean something, correct?
I do.
Okay. You used some words earlier with Ms. Pritchard. You used a trust issue, right? Nowhere in Graham v. Connor is there a concept of a trust issue, correct?
Not in the case law itself, no.
That's you, correct?
Correct, that's a part of my analysis.
But that's not, gives, as a factor to review, the trust between the two combatants is not in Graham v. Connor, correct?
That's not part of Graham v. Connor. The point of that is that we have to consider the perceptions of both sides in an analysis, remembering that Graham versus Connor is hindsight analytical tool for judgment.
Actually, sir, Graham v. Connor states you specifically don't look at the perspective of the assailant, correct?
It
Yes or
can.
no, sir?
Yes, if the officer is clearly identifiable.
Right, yes or no? So you're not supposed to look at the perspective of the other person, correct?
In judgment, no.
Correct. And so that's you kind of going outside the guardrails, fair enough? In your analysis.
For a deeper analysis, yes.
And again, you keep using the term deeper analysis. Deeper analysis never appears in Graham v. Connor, Tennessee versus Garner, or any of them, correct?
Not at the judgment level, no.
Okay. And you use a phrase, ongoing spontaneous attack. That's nowhere to be found in Graham or any of the other cases, correct?
No, it's just calling it what it is.
That's something that you created, that you use in your presentations to juries, that you use, correct?
Yeah, to help understand, correct.
But it's not something that Graham mandates that you do, correct?
No,
And you would agree with me that Graham mandates that an individual who has the elements for a criminal offense is lawfully allowed to use force to effectuate that arrest, correct?
correct.
In this situation, Mr. Mitchell had all the elements for a lawful arrest, correct?
That's correct.
He had every single right to use physical force and try to handcuff Ms. Castleberry, correct?
That's correct.
You also agree with me that the reasonableness use of force must be judged from the perspective of a reasonable officer at the scene, correct?
I didn't say that. Graham versus Connor says that.
I said you would agree with me that Graham v. Connor says that.
Yes,
Okay. You would also agree with me, as you stated earlier, you can't do 20/20 hindsight, no armchair quarterback or anything like that, correct?
that's correct.
Highly suspicious of training and studies that do that, right? You call that out.
Yes, in certain contexts, absolutely.
Absolutely. So when you're looking at the Graham factors that are outlined, that are in the verbiage and in Graham, specific factors that are mentioned there, number one, the severity of the crime at issue, correct?
This is what?
Factors in Graham that actually are in the text
Correct.
that give you guidance, correct?
Yep,
You're supposed to analyze things regarding these factors, and it's not an exhaustive list, correct?
it is not,
It's a balancing act, correct?
That's right.
No one more factor is more important than another factor.
depending on the fact pattern.
So you might play some more, but Graham doesn't tell you to do that. Graham doesn't tell you, depending on the fact pattern, you should give this factor more weight or that factor more weight, correct?
In the analysis, the jury instructions that formulate the,
So you don't know what I apologize for interrupting, you don't know what the jury instructions are in this case,
I
correct?
don't. I don't have any idea, but that's my point, is that those fluctuate. So what we're using for an analysis can be a number of things outside of the three-prong objective reasonableness standard.
I understand exactly, but if you have every factor in Graham, they're all going to be in the jury instructions, correct?
They could be,
If you only have two of the factors in Graham, those two are going to be in, correct?
correct. That's not my purview.
Exactly, but nowhere in Graham does it say, hey, you're supposed to do this one more than the other. If these are your two factors, you got to weigh this one more than the other, correct? That doesn't pertain.
Not in Graham specifically, that's at the court level,
Correct.
jury instructions.
Exactly. A second factor that's always looked at, well, the severity of the crime, you would agree with me that felonious assault is a severe crime, correct?
Correct.
And you would agree with me that when someone takes a knife and cuts someone and receives 34 stitches and a blood transfusion, that's a dangerous situation, correct?
It absolutely is,
And that's a felonious assault. It's a violent, deadly offense, potentially, correct?
potentially.
Okay. And are you aware in Ohio that if someone does lose consciousness, that qualifies for serious physical harm?
If they did lose consciousness? No, I wasn't aware of that, but I would agree.
You would agree? If
Sure.
if someone would loses consciousness, that is a felonious assault here in the state of Ohio.
Yes, I would believe that.
So if someone's attempting to choke someone unconscious and they're close, that may be an attempted felonious assault, correct?
If it's actually an attempted choke, yes.
Absolutely, absolutely. The next factor is whether the suspect opposes an immediate threat or safety to the other officers, correct?
Correct.
When, I'm not going to say this, but when Ms. Castleberry cut Andy Mitchell, she was an immediate threat, correct?
Yes, at that moment, she absolutely was.
Absolutely was an immediate threat. Whether she was actively resisting or attempting to evade arrest by flight, that's also in Graham, correct?
Correct.
Other factors, depending on the circumstances, whether it's night or day, correct?
Could be, yes.
Suspect's demeanor, correct?
Yep,
Size and stature of the parties involved, correct?
sir.
Whether or not someone's impaired and non-compliant.
Yes, sir.
You would agree with me 100% that there's two perspectives in this case on whether someone's non-compliant, correct?
There are.
And in Mr. Mitchell's mind, it's reasonable for him to believe that she was non-compliant, correct?
She was non-compliant, that's correct.
Absolutely, thank you. Whether or not the suspect appears violent is another factor to take into consideration, correct?
That's correct.
And the duration of the confrontation, correct?
Correct.
Doesn't matter how short or how long, that duration has to be analyzed.
The duration has to be analyzed. That's the timeline. The one thing that's missing from this is that a police officer that's readily identifiable as a police officer isn't one of the components of this particular case.
Sir, I understand, that wasn't my question,
Okay.
but I appreciate, because that's the second time you've offered that up, and I appreciate it.
Okay.
If you'd like to do that again, let me know, and I'll ask that question for you.
Objection, Your Honor.
Sister, just ask the questions.
Thank you, Your Honor. Body language is something that's to be taken into consideration, right?
In some cases, yes.
Under Graham. And again, I'm not going in some cases, I'm just saying these are actual factors that are outlined in Graham.
Under what jury instructions? Because they change from state to state. Are you talking about this circuit particularly?
No, sir, I'm talking about in the case, the United States Supreme Court of Graham v. Connor. Every topic that I've brought out so far is in the wording there, correct?
Not that I know. There's a three-pronged test, the objective standard test that I'm familiar with. All of the other components are jury instructions.
Exactly, that come from, in this case, State v. White.
Correct.
Okay, I apologize for that. Ignoring commands, things of that nature, can all be possible, correct?
It could be, yes.
Sudden turns,
State. I'm sorry?
sudden turns,
Sudden terms.
person turning suddenly
Yes,
could be a factor. A person moving about in an area could be a factor.
yes.
Whether or not the person's in front of you, the side of you, or behind you, correct?
Could be, yes.
All right. Now, you would agree with me, and I think you said this because you went around a little bit, that when you analyze the reasonableness of an officer, the relevant legal consideration, sir, is not whether the defendant should have done, correct?
In the initial, when I'm looking at the standard, the objective standard in my analysis, I'm looking for evidence to support the statements that create an objective standard.
I understand what you're looking for, sir, but what the case law mandates is, and they use the word specifically, not what the officer should have done, but rather what the officer in this same situation, in his or her shoes, could have believed about the situation. Those are the exact words that are used in the case law, correct?
Yes.
Okay. And you would agree with me that officers are allowed to use deadly force if they don't see a weapon, but they perceive kind of a nascent threat?
Based on the context, yes, but that context is different for every case.
Absolutely. But just because an officer doesn't see a person with a weapon, or doesn't, as long as that officer subjectively believes that the person has a weapon or maybe access to a weapon, that has to go into your analysis.
It does go into my analysis.
Okay, and at no time in this case do you know where the knife was in the car, correct? Other than when the first slashing occurred, correct?
That's correct.
Okay, and at no time, in anything you've read and reviewed of my clients, did he know where specifically the knife was, correct?
I believe there's a statement that he said he lost control of the knife and it went into the front seat.
You're going to have to find that for me, sir.
I can't remember where do you mind if I refresh with my?
Absolutely, absolutely.
Let me see what that was. I may be off on that. I don't have it here. I thought it was in the grand jury statement.
Had it been in there, you would have written that in there, correct? In your report?
Potentially, yeah.
Potentially. You just testified to, ladies and gentlemen of the jury, that you believe my client at some point had custody of the knife and
Control
dropped
of the knife.
it. Excuse me?
Control of the knife.
So-
Whether it was in her hand or his hand isn't clear.
But you just told, ladies and gentlemen, jury, that you thought my client had control of the knife and then dropped it in the front seat. That is just false, correct?
That's not false. I believe it's in the grand jury statement.
Okay.
I need to find
You
it.
can look
so-
again, sir.
Yeah.
Want to take a 15-minute break now? Ladies and gentlemen of the jury, we're going to take our afternoon break. Do not discuss this case among yourselves. Do not permit anyone to discuss it with you or in your presence. It is your duty not to form or express an opinion in the case until it is finally submitted to you. About 15 minutes. For you, Tampa. With Mark leaving so fast. All right, about 15 minutes.
Thank you, Your Honor. They should use it.
approach? Or bring it in the jury?
Okay, Your Honor.
All right, go to the jury. Do you need another bottle of water?
No, thank you, sir.
Okay. I go to Costco and buy those 40 bottled waters and for all this.
I live in Vegas, I buy them by the pallet.
Yeah, you need it up there.
Yeah.
One time I went running out there at 110 degrees.
That's a cool summer's day.
What?
That's a cool summer's day.
I wasn't sweating. Huh?
All rise.
Everyone can grab a seat. And you're still under oath.
Yes, sir.
You're still under oath. All right, be quiet. May.
Thank you very much. Mr. Bourne, I think you had an opportunity to look and see if, in fact, if you had that in your report. And
I did, Counselor. It's section 11.
Okay.
Under inconsistencies.
and what page number, sir?
It's 24.
And if you could direct me to it.
It's going to be halfway down in the sentence, or in the paragraph.
I didn't know where the knife was, that he was not aware of when she dropped the knife, correct?
Correct, and then the next line is the inconsistency.
Because conversely, when she asked about the first shots, Mitchell stated, because I knew she still had the hand on her knife. My question to you, however, sir, was, you indicated, ladies and gentlemen of the jury, that you thought my client at some point had control of the knife. That's not true, correct?
I don't think it's in my report, but as I was going back through this, there was a statement that he was in control of the knife. I don't think that meant it was in his hand. I think it was in her hand and he was in control of it. I don't remember where I saw that. It was after my report was done and I saw that statement somewhere.
Okay. But you pulled it out in reference to the ladies and gentlemen of the jury here. You might be mistaken about that, correct?
I'm not mistaken. It's in one of his statements. I just didn't, it's not in my report. I looked at it as I was going through the stuff for this
So
trial.
if I told you did a search warrant on every single one of his statements, and you will not find the thing that I had control of the knife in there, you're saying I'm wrong and you're right?
No, I'm saying that I have recollection of something to the effect of he was in control of the knife. He had control of the knife in some fashion or
Just
another.
like you had recollection of the date of the incident on the top of your report being the wrong date?
I get it, yes.
That's a yes, correct? So you would agree with me, sir, that when when an officer is involved in a use of force, they can be mistaken, correct?
Correct,
And it can still be reasonable, correct?
correct,
A mistake of fact, correct?
that's correct.
It could also be a mistaken belief, correct?
It can be, yes.
Right, and those are all to be analyzed under the case law that's laid out, correct?
That's correct.
All right. And you're familiar with the Small versus the City of Alexandria?
Not familiar with that case.
Okay.
Inherent.
It talks about where, because an officer does not know for certain where a weapon is present in order to have a reasonable belief, the suspect is attempting to gain access to one. That's a fact to say. It doesn't, just because the officer doesn't see a weapon, if he perceives one's there, he still can use reasonable force, correct?
Reasonable force based on the other issues at hand.
Absolutely.
Making distance, creating time and space, all of those factors
Absolutely.
play in.
According to you.
No, sir, according to Graham.
Okay.
According to some of the language in jury instructions across this country under Graham.
Okay. And you reviewed the jury instructions in the state of Ohio?
No, I haven't for this case.
Okay. And you're familiar with Thomas versus Baldwin, correct?
I've heard of the case. I'm not intimately familiar with that case.
If I tell you that it means possession of the actual weapon is irrelevant so long as the officer reasonably believed that the individual had possessed a weapon. You agree with that concept, correct?
I agree with that concept, but not under this fact pattern.
That's not what I asked you, sir. Do you agree with that concept as case law? We'll get into the specifics. of
As
this
case law, yes.
Okay. And in fact, you've probably heard of this quote, the Constitution does not require law enforcement officers to sacrifice their lives for the country, correct?
That's correct.
That comes from Thomas v. Baldwin.
Okay.
You've also heard, in fact, it can hardly be doubted that any person who aggressively attacks a law enforcement officer poses an immediate dangerous threat of a serious injury to that officer. You agree with that, correct?
Yes.
Because that's also in Thomas versus Baldwin, that concept. You also agree with the legal concept the number of shots in and of itself doesn't determine whether or not force is reasonable.
Plumhoff versus Rickard, I believe. Plumhoff versus Rickard. Is that
But
the
you would
case?
agree with that, correct? All right. And there's no, once a serious threat has occurred, there's no legal requirement laid out in Graham to use de-escalation, correct?
It's contextual. It depends on the case pattern, on the case facts.
I asked you if there's a legal duty advised in Graham that an officer who's already received a serious physical attack has a duty to de-escalate that situation. They do not, correct?
Yes, they do.
Where does that in Graham, sir?
That's part of the analysis. If there's time to create distance, space, and barriers, to create barriers to make other decisions, that's part of the de-escalation process.
May I approach the witness?
You may.
You're familiar with Graham v. Conner, correct?
I am.
Find for me where it says in there that they have a lawful duty to de-escalate once they received a serious physical injury.
It's not in Graham. It's part of the jury instructions. Okay. It's not in Graham.
You keep going to jury instructions, sir, and you don't know what the jury instructions are in the state of Ohio, correct?
I know what they have been. I don't know what they are in this.
Hold on. We can't have everyone speaking at the same time.
I don't know what they are in this case. I'm sorry, Your Honor.
What's your objection?
There's an objection because the jury instructions vary, and so I think it's inappropriate to be talking about what they.
Overruled based on the question. You can inquire.
Thank you, Your Honor. Let's go to something you might agree with, okay? Based on the case law and the legal concepts, Mr. Borden, when evaluating whether an officer's actions and use of force is reasonable, you are to do so in light of the facts and circumstances confronting the officer without regard to the officer's underlying or intent or motivation, correct?
That's correct.
That specifically is in Graham v. Conner, correct? That's where words matter, right?
That's correct.
Okay. I want to go to some of your opinions. If you'll turn to page 11 of your report.
Sir, I-3?
Let me get you there, I'm sorry. Your subsection 3, expert analysis, opinions, and conclusions.
Okay.
And then you get A, and that's A1, correct?
Yes, sir.
About 2 sentences down, you say, it is also my opinion that Mitchell acted out of a retribution and retaliation, correct?
Correct.
You give an opinion that contradicts what you're allowed to do under Graham, correct?
That's correct. That's part of my opinion,
Right.
my analysis.
But that's contrary to the law, correct?
It's contrary to judgment, to the decisions being made by the trier of fact. That's my opinion,
But you're
based on
giving-
the evidence.
You're giving an opinion that they're not supposed to hear, correct? You just said that. That's your opinion, but they're supposed to view it under Graham. They're supposed to view it, and you said the circumstances confronting the officer without regard to the officer's underlying intent or motivation. That is the law, correct?
Still has to be reasonable.
You put in yours, however, that you based it on what you said was retribution and retaliation. You specifically gave an opinion in your report that Graham tells you can't do, correct?
That's correct.
Okay. You also, on page 12, do the exact same thing up at the top where you say substantial attack, attempting to kill or inflict someone, the top part, substantial harm with a malevolent intent, my client did, right?
The sentence reads, Mitchell,
I'm starting, the decision to shoot were deliberate and thoughtful and not based on a response to continued attack by someone who is attempting to kill or inflict substantial bodily harm with a malevolent intent.
correct.
Okay. But again, Graham versus Connor tells you not to put that in there, correct? You put that in there.
No, sir.
Okay.
The decisions to shoot were deliberate and thoughtful. That's based on the time, the timeline. There's time in between each round. Those were deliberate rounds. They weren't.
Sir, you inserted the word malevolent intent. Malevolent means bad, right? Evil, right?
They were not based on a response to a continued attack by someone who was attempting to kill or inflict substantial bodily harm with malevolent intent. Talking about her, not him.
Okay. So someone, let's talk about her, okay? So someone who takes a knife and gashes a person, that's not malevolent intent?
Not necessarily.
Okay. Yes or no? Is that a felonious assault, sir?
It could be.
On your screen, let's talk about that. On your time frame, on states J1, the demonstrative evidence, may I have that, please? Right here, Mitchell, and you prepared this, correct?
That's correct.
Mitchell says, just cut me. He doesn't say I cut myself trying to cuff her, right? He doesn't say anything like that, correct?
Correct.
So a reasonable person can infer that the other person took the knife and cut him, right?
That's correct.
Okay. You just told the ladies and gentlemen of the jury something different, sir.
That's because part of my opinion is that that was a part of a defense from her perspective.
We'll get to the defense in just
Okay.
a little bit.
I'm just clarifying.
It's crystal clear, sir. Now, you gave an example to Ms. Pritchard on direct about the officer that's used all over the country, and you've testified about this before. And it's based on the concept that officers are supposed to preserve life, even in dangerous scenarios, correct?
Correct.
And you have a footnote on yours, correct? Footnote 23, page 20, correct? And in that analogy, if you don't mind, I'll keep talking. You're aware of the footnote, correct?
I have it here, sir.
And in that situation, and you told the ladies and gentlemen of the jury on direct, that if someone shoots an officer who comes around after bank robbery, looks like the person, shoots the officer, and then puts a hands down and puts his hands up, correct?
That's correct.
That officer should not fire, correct?
Correct.
Right. But if the officer doesn't see him put the gun down or where the gun is, he still has a reasonable belief to fire, correct?
That's correct. That's a different fact pattern. Correct.
Absolutely. And a different fact pattern, but you're the one that gave the example to the ladies and gentlemen of the jury, correct?
That's correct.
Okay. But in that fact pattern, the gun's right there and they can see it. But a reasonable officer still has to believe potentially he might have another weapon, correct?
That's correct, but that doesn't allow them to use deadly force at that moment unless the subject is making an intentional move towards
Unless
that
he
weapon.
reaches, makes, or tries to go for the weapon, correct? Okay. So if Andy Mitchell, as you know, did not know where the knife is, correct?
I'm not sure if he knew where the knife is or not based on his statements.
You read his statements. You've listened to his tape recordings, correct?
I have.
All right. And in every situation, he indicates that he did not know where the knife was during the struggle, correct?
That's incorrect.
Okay, let's start it this way. The first part, sir, did he see the knife when it was used?
I don't know if he saw the knife. He states that he sees the knife.
He asked Donna Castleberry if, in fact, she had any weapons, correct?
That's correct.
Donna Castleberry didn't say, you know what, I have a knife, correct?
She did not answer.
And he had multiple interactions with him at that point in time, correct?
Correct.
So it's fair to say that she withheld that, correct?
That's correct.
It's fair to say the size of that knife, that she had it cuffed, right? She had it hidden, right?
I can't say that she had it cuffed or had it hidden, and that's
She
not fair
wasn't
to
carrying
say.
it in her hand, right? When she got in the car, right?
I'm assuming it was in her purse.
Okay. And at some point, she reached for it, correct?
That's correct.
So what you're saying is, you think that my client saw as he was about to get slashed?
No, I'm not saying that I think it. I'm saying he said, she's got a knife.
She cut me, then she's got a knife.
No, she's got a knife. She cut me.
At the same time,
No.
correct? Okay.
The timeline depicts that. They're
We'll go-
seconds apart.
We'll go through it, sir.
Okay.
Okay. So you're saying that if someone doesn't say, she cut me, at the same time she says she's got a knife, that's an issue for you?
I'm saying that he stated that she's got a knife.
Right.
That's all I'm stating. That's the evidence.
So the evidence is that's the first time during the struggle that Andy Mitchell was aware that there was a knife in the situation.
I don't know if it's the first time. I'm telling you that at that time, he said she's got a knife.
And I'm asking you, prior to that, there's no evidence whatsoever that my client knew she had a knife, correct?
That's correct.
Okay. Now, you talk about ongoing a little bit. You used the word ongoing earlier with Ms. Pritchard, but in your report, you mentioned it on page 11, sir. And you used the term that there was an immediate and imminent deadly threat that was ongoing and occurred in perpetuity. That is on page 11, middle section. Do you see that?
And not based on the standard of an immediate and imminent deadly threat that was ongoing and occurring in perpetuity. That's correct.
And so then on page 12, okay, at the bottom section, under the 56 seconds, although it is clear through the audio recording that there was an ongoing struggle with the driver's compartment of Mitchell's vehicle, correct?
That's correct. An ongoing struggle.
So in this, you don't mention in there, do you, about her choking him at any point, correct? In those sections about ongoing struggle versus threat?
No, there's no, her foot's in his throat, and he's claiming that he's being choked. That's the ongoing struggle.
He's claiming he was choked. You're aware, sir, that his DNA was found on the bottom of her sandal, correct?
Correct.
So you're disputing the fact that he was being choked?
No, I'm not disputing the fact that he's being choked.
Okay,
That's not
but
my
you didn't
point.
include any of that in this section, correct? About the ongoing struggle or ongoing threat, correct? If someone has just slashed someone and someone is being choked, that's a continued ongoing threat, correct?
It's a continued ongoing threat,
Absolutely.
but not necessarily rising to the level of deadly force.
Is it a continuing ongoing threat?
It could be, yes.
And that went the entire time, correct?
Negative. I do not know if it went the entire time.
Okay. You didn't hear the struggle sounds. You didn't hear any of that, correct? On the audio?
What I heard, would you
Yes
like
or
me
no,
to
did
tell
you
you?
hear struggle sounds?
Actually, after she's in the back seat, what I hear is her screaming for help. I hear her
Sir,
under her breath making guttural noises, saying, okay, I'm sorry. Those aren't the sounds of a struggle. That's what I hear.
after the shots, sir. That's what you hear, correct?
That's during the shots.
Yeah, that's what you hear, correct?
That's what I hear, yes.
But that doesn't mean he heard it.
That's not the question you ask, sir.
The question I asked, sir, you won't answer.
I do not hear the sounds of an overt struggle. I hear the sounds of her.
So when you hear the sound of handcuffs, correct?
What I think is handcuffs, yes.
You hear the fight, don't put your hands on me, don't put your hands on me, right?
Correct.
You know that there's a struggle, correct?
You can hear that struggle, yes.
And then you can hear people wrestling around, heavy breathing, stuff like that, before any words are said, correct?
Correct.
And you're saying that's not a struggle?
No, you told me that you were asking me if I thought it went on the entire time. You can't hear it the entire time. You can hear the struggle when they're in the front seat. Absolutely.
The struggle occurred, you just termed it a threatening struggle was ongoing for a period of time, correct?
That's correct.
Okay. Now, we've talked about, Graham, we've talked about the choking. Let's talk a little bit more about what some of your opinion was based on, okay? I want to go to page 10, back to page 10. All right, and the first one was, you put in there, in the second paragraph, sir, and I'll quote, Mitchell states, "You don't have any weapons, do you?" To which he never receives an answer. The question regarding weapons never came up again, and no additional concerns regarding weapons were ever voiced during the contact. Sir, on your own sheet, you hear him say in the thing, a knife, she cut me. You hear that, correct?
That's correct.
Okay, so, but your phrase is that he never expressed a concern for weapons after that, correct? She never answered his question about weapons.
That's correct.
She was deceptive about that, correct?
That's correct.
It's point blank, do you have any weapons on you?
That's correct.
She lied, correct?
She didn't lie, she omitted, she didn't say anything.
Oh, so now saying, hey, I don't have a weapon, I do have a weapon, is not lying if you omit it?
No, I'm not saying that she did not answer. The facts that I know of this case are listed in this paragraph. She didn't answer. That's why I put it in here. I can't say that she's lying. I'm saying that she didn't answer. That's the fact.
But at the same time, you say that she believed that she had a perception that he was going to kidnap her, correct? At the same time, you do make that assumption, correct,
It's not
sir?
an assumption. That's based off of the evidence in the audio.
Okay, let's look at based off the evidence. In the
Okay.
audio, okay? In the actual audio, he says, you don't believe I'm a cop? And you hear her say, oh, I didn't say that, correct? She says, oh, I didn't say that.
Correct.
Okay, so that's her saying, no, I didn't say I don't believe you, right? Correct?
It's her saying what you said first. It's not her saying something else. She
He
said,
you don't believe I'm an officer. She responds, oh, I didn't say that.
okay,
Okay, right?
yes,
Okay. But somehow, now, this is an individual, and I don't know if you're aware of it, who had a warrant out for her arrest, correct?
the warrant at that time had not been confirmed.
Sir, a detective with 60 critical response teams and 18 leave detectives showed the ladies and gentlemen of the jury a warrant that was processed on August 21st, 2 days prior. Are you saying that that's not true?
No, I'm saying that the officer involved did not know about that warrant at the time of the
talking-
contact.
Sir,
Don't talk over each other. Just
we're not talking about the officer involved. Right now, we're talking about Donna Castleberry's perception and what you gave assumptions for her, okay? Donna Castleberry knows she has a warrant out, right? Because she didn't show up for court, correct?
Yeah, I don't know that.
overruled me.
Speculation. All you did on her stuff is on speculation. So there's a warrant out for her arrest. You've had experience in the vice unit, correct?
Yes,
Do female prostitutes who have arrest warrants want to go to jail?
I don't think anyone wants to go to jail.
Correct. So they will do whatever it takes not to go to jail, correct?
That's an assumption.
Dope sick, is that an assumption?
Dope sick is a condition.
It's a condition. What is dope sick, sir?
Dope sick is someone who is requiring a fix or is having a craving for some sort of methamphetamine or heroin or cocaine.
And in this situation, not only does she say that before, hey, this is where I'm going to score some dope later, right? Correct?
Correct.
Okay, so you hear that. The second thing is, in her system, you reviewed the coroner's report, correct?
I did.
And in there's very high levels of cocaine, of fentanyl, and a veterinary drug, correct?
That's correct.
All taken with at least 5 minutes prior up to 3 hours prior, correct?
Yep.
And those all have effects on an individual, correct?
They can have, absolutely.
And those all go towards noncompliance and compliance, just like Graham says, correct?
They can.
And nowhere in your report do you mention any of that stuff, correct?
That's correct because
Those are facts, correct? It's a fact that what was in her system, correct?
it's a fact that was in her system. This is a fact that was not known by the officer at the time. I told the jury.
We're not talking about what was known at his time. What we're talking about is your belief that Donna Castleberry, your entire premise is that Donna Castleberry honestly believed that he wasn't an officer, correct?
Correct.
Okay, so, but now let's look at it, the credibility of that, okay? Number one, she has a warrant out, correct? Do you think she doesn't want to go to jail, correct? We can agree to that?
Probably not.
Okay.
She probably wasn't going to go to jail.
Okay. Sir, let's go this. Are you aware that if a warrant check is run, if someone's placed in custody in the state of Ohio, and in 2018, if a warrant check is run on a misdemeanor you have discretion whether or not to put someone in custody or not
Okay.
in the state of Ohio. In 2018, if someone had a warrant, they have to go to jail.
Okay.
Okay?
I'm aware of that.
You weren't aware of that?
No.
But again, don't you think that factors into your beliefs of what Donna, and your opinions of what Donna Castleberry believed at that time?
No, they
You
don't.
heard- Okay. You heard my client say, I'm going to run a 50, right? What's a 50?
Here, I believe a 50 is a warrant check through NCIC.
Warrant check, right? And if someone who has a warrant and knows they have a warrant, and the officer says, geez, I'm going to run a 50, that person knows they're going to jail, correct? There's no discretion. Possibly? Even then, you won't agree with me that the person has to go to jail?
She doesn't know if she's got a warrant. I don't know that she had a warrant.
Okay, so she had a court date, she didn't show up, she multiple times went through the system. You don't think she knew she had a warrant out, sir?
Sir, I never saw a warrant in the evidence. That's,
Okay. You reviewed the case file, correct?
yes.
All right. And then part of the case information that was sent to you included some warrants for her and court dates, correct?
It did, and it probably wasn't relevant to my,
Wasn't relevant to yours.
That's correct.
If someone didn't want to be taken to jail, it wasn't relevant to yours.
You need to make a record or?
May I approach a witness, Your Honor?
Okay.
I'm going to hand what's been marked for identification purpose, Defendant's Exhibit 3. Now, I received this from the prosecutor's office, the same file you did. Are you telling me you didn't review that?
If it's in the case material, I saw it. It wasn't relevant to my opinions.
So in your objective and subjective balancing act, your deeper down dive, you have an opinion of Donna Castleberry, what she believed, and you don't go deeper and put that into your analysis?
I don't, because the officer at the time didn't know this. This came in after the fact.
You don't put anything in your report about what was in Donna Castleberry's system and how that might make someone react in terms of compliance or non-compliance, or whether or not they want to go to jail or not, correct?
Correct.
I've already given you the part of the transcript where she said, he goes, you don't believe I'm a police officer? She goes, oh, I didn't say that, correct?
That doesn't mean she doesn't believe he's a police officer, because there's
Now
other
you're making the
statements.
assumption, correct?
No, there's other
Okay.
evidence that says she doesn't believe that he's a police officer.
Okay, he shows her an ID that has his police uniform in it, okay?
Okay?
Number one, he shows her a U-10-100, okay? That, you can't get those in the public, even though she says you can, you can't, correct?
I don't know if you can or not.
Because you don't-
You can create those badges. I've dealt with fake badges before.
And you can create the code that scans you in everywhere and stuff like that. So in Donna's mind, she must have said, oh geez, that guy created a fake certificate, correct? So that's how far you're going to examine her perspective, isn't it, Mr. Moore? Isn't it, sir?
It's taken out of context.
He showed her his police officer handcuffs with a key, correct?
Handcuffs are available to the public.
It's a yes or no question, sir.
Handcuffs are available to the public.
Yes or no, did he not show him the handcuffs with the key, correct?
Yes.
Yes or no, did he not tell her, I'm not going to arrest you as long as you don't have any warrants, correct?
He did.
Yes or no, he showed her an affidavit and a vice document, correct?
Correct.
Okay, and those aren't available to the public. They're only available to those individuals. Do you take me on my word for that?
No, I don't.
Okay. All right.
Those are available. If somebody wants them bad enough, they can get them.
Okay, so find for me in the state of Ohio, or in the city of Columbus, how you get those, sir. How would you get that? Now, a detective, another detective and an officer all testify to these ladies and gentlemen of the jury that they can't get those because we don't want people pretending to be police officers. So you disagree with the other three officers who already testified in this case, sir?
What I'm saying is I've dealt with people that have stolen documents from police departments and made fake badges. It
And then
happens.
did this, and then did that, and then did this. All to go back to your assumption of Donna Castleberry, correct, sir?
Correct.
Now, on the bottom of page 10, okay, you indicate there was no further concern voiced by Mr. Mitchell regarding the presence of weapons until such time Castleberry used the knife in what appeared to be a defensive manner. You can't see into that car, correct?
Nope.
The word appears when you see something, correct?
Correct.
Okay, so you inserted appear into a report as though you viewed it. Now again, you know the basics of self-defense. Let's forget the case we're in now. The basics of self-defense, correct?
Correct.
It's pretty common across the country, correct? If two people are in a fist fight, a person can't insert a knife into a fist fight, correct? They don't get the self-defense instruction, correct, sir?
I'm not sure what you're saying.
Okay.
Clarify that.
In basic self-defense, you're not allowed to increase the level of force or the potential threat in self-defense and still have that as an argument for self-defense. Are you aware of that concept?
Yes.
You don't bring a knife to a fist fight. That's what's said.
Okay.
If two people are fighting and someone pulls out a knife and stabs them, they don't get the defense word, correct?
Correct.
But you use defense word here, correct?
You are losing me. I'm not,
Sir,
take a breath and tell me exactly what you mean by this.
used the knife in appeared to be a defensive manner. You used, first word is appeared, you didn't see it. Second word is in a defensive manner, okay? So what, are you saying that Andy Mitchell caused himself to get cut because she was holding it there in a defensive manner? Is that what you're trying to tell these ladies and gentlemen of the jury?
Do you mind if I tell the ladies and gentlemen of the jury exactly what I mean?
No, yes or no, is that what you're telling them?
That's not what I'm telling you.
Okay, but you used the words appeared to be in a defensive manner.
That's correct.
Okay, so again, you're starting from the premise that she had to use it from a defensive manner. However, he was slashed, correct? Doesn't?
You make this motion.
Correct.
Is that your assumption of what happened, or is that what happened?
That's the whole point, sir.
Okay,
Is that
this
you-
is,
I
this
don't know-
moon,
Don't speak over each other.
So that's
Counselor,
the
if you
whole
mind
point.
if I explain what I mean by appeared?
Ms. Pritchard will let you. do that.
Okay, that's fine.
In this situation, you make assumptions to make it though it appears she's being defensive, correct? You don't know what happened in that car, correct? You didn't see what happened in that car, correct?
No one did.
Correct. But you still give Donna Castleberry the benefit of doubt on her perceptions, correct?
Based on the evidence, yes.
You didn't challenge it with any other evidence, correct? You
With,
didn't challenge it with any other facts, the warrant, all the other things. You didn't challenge, you didn't drill down on that information, did you?
that evidence has nothing to do with the physical contact.
Okay. All right, moving on. Okay. The law, in the case law, doesn't even allow someone to say that a suspect used it in a defensive manner, correct? Nowhere in any of the cases does it say that a suspect is justified if they're using a knife in a defensive manner, correct? It's not in any of the law.
In any of what law?
But Graham v. Connor, Tennessee versus Garner, all the cases that you rely upon to form your expert opinion.
You're crossing wires here.
Okay. All right. Let's go into another subsection that you have in your report, okay? You indicate a report, you have a section, significant data from forensic and physical evidence called Officer Commands Prior to Use of Force, page 11. Okay, are you with me?
What paragraph?
Top paragraph, right under number 3, Officer Commands Prior to Using Force.
Okay.
And you indicate, at no time is there any other attempt to warn Castleberry of any intentions. Correct?
That's correct.
Okay. You've had the opportunity to review the transcript of the tape, correct?
Yes.
Okay. And you actually reviewed that, correct?
Yes.
Okay. So we're talking about the word intentions now, correct? My client's intentions, correct?
Intentions in what capacity?
In the capacity to warn Donna Castleberry of any of his intentions.
Correct.
You say at no time is there
Correct.
any other attempt to warn Donna Castleberry of his intentions, correct?
That's correct.
Okay. And you remember seeing him saying, I'm just going to cuff you for my safety, okay? I'm not going to do nothing. I'm just going to cuff you. Do you remember him saying that?
Yep.
That, in fact, is a warning or letting her know of his intention, correct?
That's correct.
Okay. So you just said he made no other attempts.
No
To
other
warn her of
attempts prior to the shots being fired.
Oh,
His intentions in using deadly force, not putting handcuffs on
and
him,
again, that's not in the law. The law doesn't require that, correct?
if feasible and safe to do so.
Tennessee v. Garber is feasible and safe, correct?
Correct.
And so at that decision, it's evolving, it's fluid, it's dynamic, correct?
Absolutely.
Okay, so it's not unreasonable that those words aren't used, correct?
Not in every case.
But you're saying in this situation that he had plenty, he told her plenty of his intentions prior to the shooting.
No. What are you saying?
He told her of his intentions to place her in handcuffs, told her of his intentions to arrest her, correct?
Correct.
Okay. So in the next section, sir, you say at the bottom of that, there were no other attempts to convince Castleberry that in fact he was a police officer and she was under arrest for charges linked to solicitation and prostitution. Okay?
Yep.
You are aware that right below where we just talked, it says, by Andy Mitchell, you're being under arrest.
Yes.
That's
Talking
notifying.
about from the beginning of what the struggle is being heard before she goes into the back seat. Before he uses deadly force, there's no warnings of his intentions to use deadly force.
And that's not a requirement if it's not feasible, correct?
That's right, if it's not feasible.
Okay.
Very important.
But you don't put those words in your report, do you?
No, I don't.
No. Now, Now, you also base, I think, some of your opinions on what Donna Castleberry believed by the fact that she called out for help to somebody, correct?
Part of that is part of the evidence, yes.
Correct. And part of the evidence is that she was in a normal conversational tone at that point. Hey, can you help me, so to speak, right?
And she was in the front of the vehicle, yes.
Correct. And at that point in time, the individual who was outside left, correct?
I'm not sure if they left or not. I don't know where they went.
Well, they weren't in view of the camera, correct?
They weren't in view of the camera. That is absolutely accurate.
Okay, so, and they're seen leaving the camera area, correct?
Once they're off camera, I don't know where they went. I don't have that information.
I'm not saying you do.
Okay.
Okay, but in that situation, that person was there, correct? And continued to walk out. Then there's about another 15, 20 seconds before things heat up, correct?
About that, yes.
Okay. So a fact is, you don't know if the person was still there, correct?
That's correct.
But you used the term that she called out to them. On the fact, Donna Castleberry called out for help to a stranger and requested they call for police. You used that, the person's not even there when she says that, sir.
It's not about the person, it's about Donna Castleberry.
Exactly. Whether she's telling the truth or she's lying about whether or not he believes she's a police officer, correct?
What? You've taken this completely off track.
No.
She's
Your
yelling
report is
out.
taking
All right,
this off
guys,
track.
guys,
Okay.
do not speak over each other.
Sorry, Judge.
Question, give an answer. Otherwise, Tammy will speak there.
Now, page 15, sir. Top part, analysis of movement and time compression. You put in there, at the time shots were fired, period, there is no possible way that Castleberry could have continued to harm Mitchell at that point in time. Correct? Those are your words.
That's correct.
You don't know where the knife is at that point in time, correct?
That's correct.
You don't, she might have the knife, correct?
She might.
She might have the knife as she's going from the front to the back. She has the ability to slice his neck right there, correct?
Potentially.
Okay. And she gets behind him, correct?
Into the back seat, correct?
Correct. And you would agree with me that a person can be more dangerous if they're behind someone than in front of them, correct?
Absolutely.
Okay. All of your studies that you reference in this report are straight ahead studies in a sterile environment, correct?
Correct.
Okay. So you indicate that there is no possible way that Castleberry could have continued to harm. They were within an arm's length or so most of the entire time, correct?
She was in the back of the seat with her back against the seat, so I'm not sure exactly how long her arms were. He's in the front seat, and she's in the back seat, locked in.
And as she's going from the front to the back, he could perceive that she has the knife, correct?
He could.
It's reasonable.
He
Right?
could perceive that.
And when she gets to the back seat, he could perceive that, in fact, she has access to the knife, or another knife, or something else, correct?
Could perceive that,
And as
yes.
long as that's an honest belief, he could be mistaken about that, correct?
Potentially.
Yes.
But that fact pattern doesn't align with the time constraints of decisions under the compression of time.
I understand, sir, and again, you covered that in detail earlier, okay? Make sense?
Makes sense to me.
You
Yeah.
got it. Now, let's talk about another case you reviewed in the past, okay? And specifically with regards to statements, okay?
Okay?
You remember the case of the Phoenix Police Department with Officers Cook and Ferragamo, correct?
Yes,
You were prepared a report for that, correct?
correct.
Okay, and in that report, that case involved a suspect with a firearm, correct?
I believe so. I'm not exactly sure of the case facts. That's a while ago. Do you have a copy of that I
Sure.
might read? Okay.
May I approach, Your Honor?
You may.
This is Defendant's Exhibit 17 for identification purposes.
Maricopa County, yes, I'm familiar.
Okay, and in that situation, the suspect was armed with a firearm, however, he didn't use it, correct?
That's correct.
The officer shot him dead, correct?
That's correct.
And in your analysis of that case, you opined that the actions were potentially dangerous from the perspective of the officers, correct? But the actions of the suspect were real actions, posing a very real and immediate threat to the officers, correct?
That's correct.
So in that situation, there was a real threat, correct?
That's correct.
And in this situation, it's a real threat when he gets cut or sliced, however you want to categorize it, by the knife, correct?
That was a real threat.
That's a real threat. In your analysis of the Phoenix case, you explained the decision to use deadly force must be based on possibility of deadly attack from the suspect, not the possibility of a deadly attack, correct?
The probability, that's correct.
Absolutely. Probability of a deadly attack, not the, from the suspect, not the possibility of the deadly attack, correct?
That's correct.
And in words of probability and odds, the odds are probably higher after someone's already committed the first attack that they might commit the second attack, correct?
That's speculation. I can't make that speculation.
Okay, okay. Okay. And in that case, you specifically opined you did not take into consideration any of the suspect's intent in that case, did you, sir?
That's correct.
Okay, so in that case, you didn't use any of the suspect's intent, but in this case, you used the suspect's intent, correct?
Correct. Very different fact patterns.
Not saying it's not, but and that's why Graham says you're not to consider it, correct? You use it in your analysis.
In this analysis, I did, yes.
Correct. Now, also, sir, you contemplate in this report, on page, 15 and 16, I'll go back to this report.
And which report are we at?
Your report on this case, sir, I can take the other one back. So if you don't get confused up there. Thank you, sir. And let me find it specifically. You contemplate, sir, that if Donna Castleberry, in the middle, page 15,
Okay,
under analysis of movement and time compression,
okay,
middle of that first paragraph, if Castleberry would have still had the knife and intended to use it on Mitchell, it is my opinion she could have.
correct.
Right? And we just talked about that, correct? But you're saying the fact is that didn't happen, right?
That's correct.
That's hindsight 2020, the fact it didn't happen, correct?
Right, it never occurred. That's part of the evidence. Hindsight, 2020,
Not
correct.
to be considered. So the fact that it never occurred is not to be considered, correct? Okay. Now, a little bit below that, sir, on the same page of 15, in the suspect and the action and time analysis, you indicate that there were attempting to escape from Mitchell's grasp. Approximately 2 full seconds had elapsed as Castleberry maneuvered herself into the back seat.
Correct.
You see that? Okay, so you're giving an opinion there of what you saw and heard on the video, through that video, that it took her 2 seconds to get back there.
Approximately 2 seconds, correct.
And 2 seconds is plenty of time for someone to cut someone in the neck, correct?
It is plenty of time, yes.
Plenty of time, ample time, plenty of time to be moving and stab somebody, correct?
It could be,
And
yes.
that's reasonable for my client to believe that, correct?
If she was moving towards him or away from him.
Well, if you're coming from the front and you're going right here, you're coming towards him, then to the side of him, correct?
Correct.
And it's reasonable to believe that if the person gets behind you, that they could be stabbed from behind, correct?
It could be, yes.
Okay, all right. Now, you base your opinion here on the officer having reassessed the threat, correct? You analyze that in terms of time compression.
Are we looking at,
No, sir, just in general. You told Ms. Pritchard on direct
okay, tell me again?
that you base your opinion on an officer to reassess the threat, correct?
Correct, constant reassessment.
And you call that a component of the time compression, correct?
Time compression can guide the assessment. If there's not enough time to assess in a spontaneous, continuous attack, there's no time to assess, you respond to that directly. We're looking at the time that existed to assess.
Absolutely. And you were recently interviewed a time ago by a police magazine, correct?
That's correct.
And you said that the focus and attention should be taken into account when you have a time compression event, correct?
Correct.
And in those situations, certain things can happen. And I think your words were, an officer is focused on a significant visual, auditory, tactical perception that is a consequential to life and death, correct?
Correct.
And that's what you meant earlier with the ladies and gentlemen of the jury, that one person might focus on this, one person might focus on that, and those all play a part of it, correct?
Correct.
And you used terms in that interview that you did, or that article, about auditory exclusion, correct?
Yes.
Tell the ladies and gentlemen of the jury what that is in general.
Generally speaking, auditory exclusion simply means that you're not processing sound. It's not that you go deaf. It's not that your ears fail. It's that you're so intently focused on something that the auditory stimulus is not processed by the brain. So you may not remember hearing it, but it doesn't mean that it didn't occur, which is what I talked about in Officer Mitchell possibly not hearing certain aspects of this event, and I can't make the determinations based on potential auditory exclusion.
And that same concept, sir, can be done with inattentional blindness, correct?
That's correct.
Same concept. The person doesn't go blind, but they kind of get, the vision gets narrowed to something.
Correct. Inattentional blindness is simply you're so focused on one particular thing that whatever you're not focused on, you become inattentionally blind to. And it can be very close. It can be a person standing right next to another person. It can be very close. That's referred to as inattentional blindness.
We also have tunnel vision and tachypsychia. What is tachypsychia, sir?
Tachypsychia is the speed of the mind. Officers that experience an event can experience time speeding up or slowing down. If you've ever been in a critical incident like a car accident or something of that nature, you may have a slowed memory of it. It doesn't actually slow time. It's a process cognitively that makes thoughts appear faster or slower to you as you perceive them.
And all of those types of things can affect someone's reaction time on firing in the shot sequence, correct?
They can, yes.
Okay. And so if someone has experienced something slower, they're going to probably react slower, correct?
No, that's not what it means.
It's a poorly worded question, but they affect different people in different ways.
So tachypsychia doesn't necessarily affect the response time. It affects your perception of it. So you are still acting at the same speed. In fact, you may be even acting faster, but you perceive it slower. It has nothing to do with the actual response time. It's how you perceive the response time.
And those concepts you try to use because you're very wary of trainers who don't acknowledge those concepts, correct?
No, I wouldn't say that I'm wary of them. I would say that it's important to consider them.
But you're wary if they're being judged only on that. How's that? Is that a better statement?
No, people are not normally judged on these components. These components are usually overlooked in the judgment of a case.
And what that leads you to is judgment in hindsight that you are very wary of.
Correct.
Okay, very good. And you testified a little bit, and you have in your things about the Hudson studies, correct?
Yes.
Okay, in the Hudson studies, that's where you talk about the reaction time and things like that, correct?
I believe so, yes.
Yeah, and in that situation, it's in a sterile environment, correct?
That's correct.
And the studies focus on one target in front of them, correct?
That's correct.
And they aren't done in a confined space where someone's in a car seat, correct?
That's correct.
They're not done where someone has an injured hand, correct?
That's correct.
They're not done in a hyper-evolving stressful situation or struggle where someone has been choked, correct?
That's correct.
Okay, so the studies you're talking about are just in a laboratory and very sterile.
They're a baseline empirical data based on human movement.
And all of those situations can affect reaction time or shot time, correct?
They can, yes.
Okay. And you actually like to write you've written articles about, you want to define consistency in an inherently inconsistent profession, correct?
That's correct.
That's part of your beliefs that you're pushing forward.
It's identifying consistency in an inconsistent world, correct?
Exactly. And you indicate in that same concept or theme is that most cases analyzed in retrospect, no policy or procedure would have prevented or changed the outcome, correct?
That's correct.
Okay, and that's retrospect means hindsight, correct?
That's correct.
Okay, and you're actually in that same vein, you train that, hey, deadly force the deadly force has to mainly focus on the actions of the assailant, correct? Not the words of the subject.
Yeah, the deadly force is incumbent on the actions.
Correct.
An officer's response to a subject, it's incumbent on the subject's actions, and it's our responsibility. It's the officer's responsibility to be in a constant state of assessment to initiate deadly force, which is obviously the highest level of force an officer can use and is the consequence of life and death.
And not the words or the mindset of the subject, correct? The actions are the key.
It's the actions, that's correct.
Okay. And that's where action versus reaction comes from, correct?
That's correct.
And action versus reaction, meaning that a reaction is never as fast as an action, correct?
A reaction is never as fast as an action, that's correct.
I'm always going to get hit first, correct?
If somebody's swinging, that's right.
Chris Rock didn't know he was going to get hit,
He
correct?
sure didn't. Great example.
Correct, didn't know he was going to get hit, right?
Nope.
Now Chris Rock, might think he might get hit again, correct?
Well,
Reasonable to believe, right?
I don't believe so. His arms went right behind his back, and he never touched his face, which was a stud move, so.
All right, let's go a little bit, sir, about, just, in your report, you base it, some of it, and I think what Ms. Pritchard said about inconsistencies alleged by my client, correct?
Yes, section 11?
Yeah, part of that. You've offered an article, however, where more officers than ever are being charged with crimes, but is simply a witch hunt based on false premise. That's an article you authored, correct?
What's the name of the article?
I'm sorry, you authored an article called "More Officers Than Ever Are Being Charged with Crimes, but is simply a witch hunt based on false premise."
I think is that through Caliber Press?
I think so, yes.
I'm sorry.
We'll put
Okay,
up
it doesn't matter.
Sound
It
familiar?
sounds familiar, yes.
Okay, very familiar. And there you state that an officer's account of a critical incident will always lack, this is the quote, "perfect accuracy," correct?
That's correct.
Because of the limitations that prevent the officer from knowing what we know after the fact.
That's correct.
So they should be inconsistent, correct?
They can be
They
inconsistent.
can be, but here you criticize the inconsistency, even though you train and teach that there's going to be inconsistencies before you even start the analysis, correct?
The inconsistencies for this purpose in this is the part of the evidence that is stating whether the officer knew where the knife was at any given time. Those inconsistent statements are what I'm analyzing in this report.
All right. I want to turn briefly, and I'm wrapping it up, I promise you, to page 7. You talk about some significant facts and related to this analysis. So these are facts that you term undisputed, correct?
Yes.
Okay. So I want to turn to page 9, number 30.
Okay.
A fact that you say is undisputed is no other officers were notified of Mitchell's intent to conduct police business in an undercover capacity at the place and time of contact, correct?
Correct.
Okay. You are aware, sir, that as a group, they all left the range kind of at the same time to go work individually in the same area, correct?
I know that they left the range. I don't know that they were working individually in the same area. I don't know what the other officers were doing.
So you didn't read in the reports that as a group, they decided to go work the west side and the bottoms?
I believe they were on their way to work in another area. That they,
And then in that situation, you were aware that, based on your review of the case, that they communicated together by texting, correct?
correct. That's the way they were communicating.
And
yes.
you were aware that they were all in the same general area and that they would text where they were at or what they were doing, correct?
Correct.
And in this situation, you reviewed text that said, hey, where are you guys at, right?
Correct.
A response was given, correct?
I believe so.
And then Andy sent a text out, Bellows and something, correct?
I think so.
And then Bellows and Yale, correct?
After he found out where that location was at, yes.
Correct, she told him.
Correct.
She directed him to there,
Right.
correct?
Yes.
So then Andy, so those are all attempts, correct, Mr. Borden, of him telling other people what he's doing, and hey, she doesn't believe I'm a police officer. Those are all attempts that notify other officers. You realize in that text chain, there's 5 people on it, correct?
I know there's a group, yes.
Okay, so you would agree with me that those are all attempts to notify that he was undercover, doing business, doing police business, correct?
Yeah, unfortunately, I don't remember looking at that text string.
Okay. May I approach the witness, Your Honor? What was the last one, Ms. Stevens? I'm handing you what's been marked for identification purposes only as Defense Exhibit 18. If you remember seeing any of those documents, it's a 2-page document, take your time and review it.
Yeah, I apologize. I haven't seen these documents.
So had you seen those, I mean, they were provided to you.
Okay, yeah, and I don't know how I missed them, but I didn't see them.
Okay, so you missed them. Had you seen these, you might agree with me that in fact, it is a disputed fact, correct?
Yes,
It's definitely a disputed fact. There was plenty of contact telling that he was undercover and what they were all doing, correct?
correct.
Okay. Go to page 7, or page 8, I'm sorry, number 4. Okay?
Okay,
You put as an undisputed fact, Mitchell parked his unmarked undercover vehicle behind a building and out of sight, correct?
correct.
Have you been to the scene, sir?
Yeah, well, no, I haven't. I've only seen it on the video.
You've seen on the video. Have you looked at the pictures of the scene?
Yes.
You realize, sir, that you can see where the car was parked from the road?
You can see the tail of it, yes.
Okay. You realize that another road's behind the building and comes up and around?
Yeah, I looked at a Google map.
And you realize that you can see it from over the side road as well, correct?
Correct.
So that car was not out of sight, correct?
It was out of the main view of the main drags. It was parked up against a building.
Sir, the only thing it was out of sight is if you would be on the other side of the building and couldn't see through the building, correct?
Correct.
It's visible from 270 degrees, correct?
I'm not sure. Haven't been to the scene.
So it's not hidden, right? It's not out of sight, correct?
If you're saying it's not, my purview of it was that it was out of sight except for the tail end of the vehicle.
And you've been in town since Tuesday, correct?
Yes, that's
There's no
correct.
reason you couldn't have examined the scene. The ladies and gentlemen of the jury were out at the scene and they examined it. There's no reason you couldn't have, correct?
I probably could have if I had time, yes.
Okay. If you had time on Tuesday or Wednesday?
Correct.
Okay.
I've got Zoom depositions and other business going on.
All right. Again, I think we've gone over this one, 19. Fact, Castleberry uses a knife to prevent Mitchell from placing her in handcuffs during the encounter. That's your undisputed fact, right?
Yes, based on the evidence that I reviewed, yes.
Based on the evidence you reviewed, it's also potential fact that she committed a felonious assault on him, correct?
Not
And that's
from my
why he
purview.
couldn't get the handcuffs on, correct?
No, that's not my purview. That's not my opinion.
Okay, but you agree that that's a disputed fact, right? That's not your opinion.
They were attempting to put her in cuffs, and she used a knife to prevent it. That's a fact.
So she didn't use the knife to like block it and say, no, you can't use the cuffs. She cut my client, correct?
There's a slash, yes.
Okay. Okay. Next one, 21, while we're talking about cuffs, okay? Undisputed fact, a struggle ensues as Mitchell continues his attempts to handcuff Castleberry until the handcuffs fall out of the vehicle, correct?
Correct.
When you open a door, something falls out, correct?
What's the statement?
When you open a door, something might fall out of the door accidentally, correct?
Could.
On that video, you see a hand take the cuffs and throw them out, correct?
Correct.
So they didn't fall out, correct? They
Yeah,
were placed there by Miss Castleberry. They were thrown down by Miss Castleberry.
Yeah, they fell out of the car. They were placed out of the vehicle.
So you believe that you use the word fall out. You don't say that I viewed an undisputed fact that Miss Castleberry took the handcuffs and threw them out of the vehicle. That's the undisputed fact, correct?
Correct.
Okay, but you chose to word it a different way.
Obviously.
Obviously. 27 and 28. Take a look at those, sir. Page 9. Undisputed facts. Mitchell did not radio or call for additional units. Mitchell requested a citizen down due issue of not having any other effective form of communication. You agree with me now that you're wrong about those, correct?
No, I don't.
Okay. So you want Andy Mitchell, while he's in this struggle, to call someone on his phone. That's what you're saying here.
No.
Okay. So in number 27, Mitchell did not radio or call for additional units or police assistance any time during this incident. Isn't it a fact, sir, that he texted people to come here? Correct?
Correct.
Isn't it a fact that he sent a 10-3 for people to come here?
I didn't see that. You're correct. But there's no radio. He didn't use any radio to call for backup.
He didn't use Morse code either, correct?
That's correct.
He didn't use sign language, correct?
Correct.
He didn't use a can with a thing on it, correct?
Yeah, that's on page 11.
Yeah, a can with a
Can with a string. Yeah,
can with
right
a
here
string.
on page 12.
And again, but seriously, sir, he did in fact communicate with them.
He did, and I know
was-
that now.
And that was their policy at that, correct?
I don't know what their policy was. I didn't see any policies regarding vice contact.
So you've been a vice officer and you're an expert, and you didn't review the Columbus vice policies in this case?
The vice policy doesn't say anything about contact. The vice policy is nearly non-existent.
Does the vice policy say anything about requirement to have a badge when you're undercover?
It talks about the danger of having a badge when you're undercover.
No. The vice policies for Columbus Police Department say you don't have to have a badge when you're undercover. That's the policy. You haven't reviewed those, have you?
I have. I have reviewed
You
that.
would know that that's the policy, correct?
Yes,
Okay, so it's not required when you're undercover to have your badge on you.
it's not
Per
required.
policy,
Per
correct?
policy, that's correct.
But you still think that it's some form of non-effective communication, the texting, and that's how they communicated. You would agree with me that that is a disputed fact, correct?
It's not that's not an effective form of communication when there's a critical incident going on.
So voice activation of a text you think is not as effective as, hey, hold on, Miss Castleberry, while you're choking me. I got to make a call here right now, and I got to dial the number, right? You think that's a better form of communication, correct? That's what you're telling the ladies and gentlemen of this jury?
No, it's not about the communication. It's about the contact with this subject with no other contingency, if you
Was
want to
there-
get into that.
27 and 28, you indicate that there was no communication sent out, okay? There were, correct? That's a fact.
That is a fact.
And again, these are facts that you put into your report, that you deem important, correct?
Correct.
You don't put in there anything about the choking, correct?
No,
You don't put in there anything that his DNA was on the bottom of his sandal, or her sandal.
didn't put it in
You
there.
don't put anything in there about what was in her system, correct?
I don't.
You chose what to put in here, correct?
I chose the facts that were relevant to the force that I'm analyzing, which are the shots that were fired.
Sir, you just agreed with me that you're wrong on at least 4 of those right off the bat, correct?
3 of those facts, yes.
Now, at a basic level, if there's a struggle, if there's a critical incident or an immediate threat, right? There should be a timing, right? But if there's a struggle following that, that's going to extend the time frame of the struggle, correct? Of the incident.
Yes,
Okay. And in reaction time, if someone's involved in that struggle, there's fatigue, correct?
possibly,
Exhaustion, correct?
could be.
And based on the reaction time of undoing, now, when my client had her hands, when her backside was up against the windshield, and her foot was under his throat, and he had her hands, okay, at that point in time, you're aware that he made a decision because he believed that he was going to lose consciousness, correct?
Correct.
And so at that point in time, the moment he lets go and goes down to unbuckle, he's got to unbuckle, right?
Correct.
Because he's buckled in during the altercation, correct? During the struggle, right?
Based on the evidence, yes.
He's buckled in when he gets slashed, correct?
I believe so.
So that you're saying that then, so his attention goes off of her over to this unbuckle, right?
Correct.
And the facts are that he had to hide his gun in a place so she wouldn't see it, correct?
That's correct.
So it's not on him like in the studies. It's not readily accessible. He's got to find that, correct?
Between the seats, correct.
He's got to take the out of the holster, correct?
Correct.
And then he's got to re-engage, correct?
That's correct.
And at that point in time, he doesn't know where potentially she is or where the knife is, correct?
I can't say. I'm assuming he doesn't know where they're at that time based on his statements.
Very good. I appreciate that.
Except for the one statement that says he knew she had the knife right before he fired.
Okay, we'll cover that. Don't worry,
Okay.
sir, okay? So, again, in the Phoenix case, sir, you indicate that it's important to remember that reaction decisions also take time, and these increments of time must be recognized and considered in the reconstruction analysis of a force incident. Those are your words, correct?
Correct.
So the same thing has to be done here, correct?
Absolutely.
All right, and in Tennessee versus Garner, there's 2 paths that someone could take to use deadly force, correct? There's 2 alternative potential reasons when an officer can use deadly reasonable force, correct? And one of them is if there's probable cause to believe that a suspect has committed a crime involving the infliction of threatened infliction of serious physical harm, correct?
Right.
Okay.
Attack.
Exactly. And then Scott versus Harris drills down even deeper on that, right?
Correct.
And Scott versus Harris says this person, in committing a violent felony, has seriously injured or killed others, or has threatened to do so, and will continue unless stopped or he has attempted to fleeing the scene of that crime, correct? That's reasonable, correct?
Correct.
Okay. Now,
Counselor, can we take a bathroom break?
Yeah, take,
it's my last comment.
Oh, that's fine. That's fine.
No, with all due respect, you got to go, you got to go.
No, listen,
No,
I've also got cop ladder. I can work it out. Let's do that.
if you're gonna finish up, then we'll take a break after that.
Yeah, so some of the studies and training you've done, sir,
Yep.
And I think this study, if I believe I'm right, is you did a study and you taught on a study out of actually the Henderson Police Department, correct?
I'm not sure what you're talking about. There's a lot of,
Oh, okay. I'm sorry. I apologize. The death of Jesse Vigil. You used that in some of your training seminars, correct?
yeah, it sounds familiar.
Well, it was the Henderson Police Department in 2014. You were employed then, right?
Yes.
So you probably were aware of the law enforcement officers, your fellow.
Yes, Jesse Vigil. Yes, I actually investigated that crime. That's correct.
Okay, and you teach off of that, correct?
I do.
All right. And you actually sit on committees that help teach this, correct?
That's correct.
All right, it involved a Henderson Police involved shooting by Henderson Police that took place in 2014, correct?
That's correct.
You were on the force and you were involved in that situation, correct?
That's correct.
You were aware that the officers were cleared in that situation, correct?
Correct.
You've incorporated that case into a lot of your trainings on use of force, correct?
I have.
You've shown cruiser cams of that, body-worn cameras and things of that nature, correct?
I have.
In that case, the case you train on, the suspect was stopped for running through a red light on a bike, correct?
That's correct.
And the officer patted the suspect down for safety, correct?
Yes.
And in there, the officer found a folding knife that was concealed, right?
Yes, I believe.
Wasn't visible.
That's right. They took the knife off of him.
And the suspect, they then took the knife, and the suspect did not tell the officers he had a weapon, right?
No,
And the knife was then removed and placed on the windshield of the cruiser.
that's correct.
All right, and in that situation, when the officer was deciding to place him in custody or not, he was deciding whether to place him in custody or just give him a summons, right?
They were building a case and they had gotten a message from the detectives that he had just committed a murder.
Right, so they were trying to decide whether or not they were going to take him to custody, correct?
Correct.
Once that determination was made, a physical struggle happened, correct?
Correct?
During the struggle, the suspect was able to get another knife, correct?
1 of 5, that's correct.
Right, and he stabbed the officer in the hip, correct?
Yep,
Thereafter, another officer unloaded his duty weapon and killed that suspect, correct?
that's correct.
And that officer none of those officers got charged, correct?
They did not.
Mr. Borden, I appreciate your patience to go to the bathroom. That's all the questions I have for you now. Thank you.
Thank you.
Ladies and gentlemen, let's take a 5-10-minute recess. Hold on. Do not discuss this case among yourselves. Do not permit anyone to discuss it with you or in your presence. It is your duty not to form or express an opinion on the case until it is finally submitted to you. You guys all have a seat. Las Vegas has grown so much.
It's unbelievable. Born and raised there. There's 50,000 people when I was born.
I don't know where they are. I was going out to Vegas with my parents, probably early 70s. Back when it was real.
Yeah, it's, I went to school with Spilatro's kids. And, gangster days.
Yeah, that was a whole different deal than it is now. Back on the record, 19 CR 1662, State of Ohio versus Andrew Mitchell. Do we need to put anything on the record prior to bringing in the jury?
No, Judge.
Go get the jury. I used to live in Los Angeles and Las Vegas all the time.
Especially back then.
All right, everyone can have a seat. Any redirect?
Yes, thank you, Your Honor. This-
Oh, you're still under oath.
Thank you, sir.
Mr. Borden, the last thing you were talking about is the Vigil case with Mr. Collins. Vigil case is not this case and not these facts, correct?
That's correct.
The report you prepared here is 36 pages long, is that right?
I believe so. Yes, ma'am.
Very good. Now, I know Mr. Collins didn't want to hear your answer, but I'd like to. Would you like to clarify the timing of you taking this case with respect to taking cases that are indicted or not indicted?
Yes, so the point being is that I wasn't asked for a specific opinion in this case. The process had already begun, but I was retained to give my objective opinion, not one way or the other. I wasn't told what was required of me in this case. In the other case I was talking about, and I should have clarified, I was asked to write a report to support their purpose. And it happens often, and that's just not something I will do, so I apologize for the confusion.
So you were asked to, whichever way it was going to come out, give an opinion.
Correct.
I believe you told Mr. Collins you recalled references to the defendant having control of the knife.
Correct.
And you said you had information regarding some other statements from Mr. Mitchell.
Correct.
And I don't know if you have page 45. I'm not sure what materials you still have up there.
Limited, only my
Okay,
stuff.
very good. Would the statement, "I had both her hands and the knife with both my hands," be a statement that you had read?
Yes.
And a statement such as, if I go out, she is going to take this knife. Would that possibly be one of the references you had?
Yes, that was another reference.
And possibly, I had the knife, I had a wound to my hand. Would those be the statements you were referring to, talking about inconsistencies about control of the knife?
Yes, ma'am. And those were not in my report.
Very good. The Graham factors, we have said they are non-exhaustive, correct?
Correct?
Many factors to consider.
That's correct.
And you have noted an important factor here was whether he was readily identifiable as a police officer, is that right?
That's correct.
And the ability to create distance and space with that open door, a factor.
Correct.
There was also, you wanted to finish page 10 at the bottom. I believe you wish to explain the statement, until such time that Castleberry used the knife in what appeared to be a defensive manner, and you were not permitted to. Would you like to explain that now?
Yes, please. So appeared doesn't mean I could see it on the video. You can't see anything like that inside of the vehicle. The appearance is that from the evidence, we hear the attempts of putting somebody in handcuffs, and the way that that wound is across the hand, it appeared as if that weapon was drawn across the inside of the hand, not a stab, but drawn across the inside of the hand, the way the hand was slashed. That's all I was saying. That appears to be a wound consistent with somebody who is pulling away and trying to get out from the grip and control of someone. That was my point.
And saying we don't use hindsight doesn't mean that you can't say the officer was wrong. You just can't add factors that the officer didn't know about. Is that correct?
That's correct.
So you can look at what he knows and come to a different conclusion.
Absolutely.
That doesn't mean it's hindsight.
It doesn't mean it's hindsight. It's part of the analysis. We can't take, do you mind if I continue to explain
Please
just a
explain.
little bit? You can't take every piece of evidence at face value. Everything has to be interrogated to a certain extent. So some of this information that is remembered, and we say, okay, well, that's perception, that's just carte blanche. That's not a checks and balances kind of issue. That doesn't make it automatically okay. It still has to be analyzed.
And the focus is on the facts known to the officer then.
At the moment, that's correct.
So the warrant she had, that he had not verified, was not known to him then. It was not important to your analysis.
That's correct. I didn't consider the warrant as part of my analysis. It wasn't information that was known to the officer at the time of the use of force.
In reviewing the factors known to the defendant here at the time, what was your conclusion as to whether this was objectively reasonable?
I still take the stand. My opinion is during this analysis and the objective standard not being met with the evidence available, that this is not a reasonable use of force per the Graham standard.
Thank you.
Any questions as a result of those questions?
Briefly, Your Honor, just based on those. Mr. Borden, you just told Ms. Pritchard that you have to go after the integrity of someone's beliefs, correct? You have to challenge those beliefs, correct?
Interrogate, yes.
Interrogate. You have to
Yes.
interrogate those beliefs, correct?
Absolutely.
You didn't interrogate Ms. Castleberry's belief of that she could be lying about whether or not she believed he was an officer, correct? That's a reasonable conclusion based on what you know, correct?
It's the only information I have because I can't read a statement. The information I have is her actions in the vehicle. I don't have the ability to get a statement. There's no statement from Donna Castleberry.
That wasn't my question, sir.
What's your question?
My question was, you have this premise that she didn't believe he was an officer, correct?
That's correct.
It's a fair, reasonable thing to say that she might have been lying about that, correct?
She may have been
Okay,
lying.
and that's a fair, reasonable thing, correct?
It could be, yes.
And that's why when you look at interrogate that type of evidence, you have to look and see, well, geez, she had a warrant out. She was going to score dope. Do you realize she had possession of heroin? Do you realize she had heroin on her?
Yes, she was involved in criminal activity.
Possession of heroin's a felony, correct?
Yes,
And you have to go to jail when you commit a felony, correct? There's no summons in the state of Ohio.
that's correct.
So when you interrogate that type of belief, you have to look at, well, geez, Donna Castleberry knows she has heroin in her purse, right?
That's correct.
Okay,
And
so-
that's part of the analysis, but it's only part of it.
Correct, sir. But the fundamental concept here, the actions that my client perceived, correct? You would agree with me. He perceived her resisting, correct?
At a point, yes,
He perceived her noncompliance, correct?
correct,
He perceived that he was in a struggle with her, correct?
correct.
He perceived that, you dispute this defensively, but he perceived that she slashed him and cut him, correct?
Yes, he perceived that, yes.
He felt it. It actually happened, right?
I don't know if he felt it. He said he didn't feel it, but yes, he perceived it.
Okay. He perceived the slashing of that, correct?
Correct.
He perceived her choking him with her foot under his throat as he pulled, correct?
That was his
And all of those are reasonable things to perceive based on what he knew about the facts then, right then, correct?
Absolutely.
And once he let her go because he feared for passing out, because if he passes out, it's over, right?
Correct.
Slice and dice, you're done, right? If he passes out. So he made the conscious choice to perceive, hey, I'm going to be unconscious. That's a fair thing for him to perceive, correct?
It is.
And in that situation, once he lets go, his attention's diverted, right? And now,
Yes, placebo, that's correct.
and a reasonable police officer has to believe, and it's reasonable for that person to believe that the person still has the knife, correct?
It could be, yes,
And especially if he doesn't know where the knife is at this point, correct?
depending on which statement you read, yes.
And sir, once he let her hands go, he doesn't know if she has the knife or not, correct?
By whose statement?
But when he's not reaching for his gun, watching her hands, right?
His statement is that he saw the knife when he fired the first two shots.
Okay, sir.
Okay, that's part of the evidence. That's what I have to analyze
The
that.
question is, once he lets go of her hands, he's on a different stimulus, correct?
Potentially, yes.
And he doesn't know where she is or doesn't know if she has the knife or not, correct?
I don't know. I can't tell you that. All I can tell you is what the evidence states.
It's reasonable for him to believe that she still has the knife, correct?
It could be, yes.
And even if he's mistaken that she had the knife when he fired the first two shots, that's a reasonable mistake, correct, sir?
Yes, it could be a reasonable mistake.
Absolutely could be a reasonable mistake. So the fact that you say, well, she had the knife in the first two shots, she may have or she might not have, but that's something that a reasonable police officer under our laws can be mistaken about, correct?
It can be, yes.
Thank you very much, sir.
Thank you. You can take all your stuff.
Your Honor, I brought 0 things. I'm going to leave
Oh,
the exhibits.
if you didn't bring anything up there, leave it there.
Your Honor, thank you for the opportunity.
Ladies and gentlemen, we're going to take our evening break now. Do not discuss this case among yourselves. Do not permit anyone to discuss it with you or in your presence. It is your duty not to form or express an opinion in the case until it is finally submitted to you. You guys are doing a wonderful job coming in on time and getting started. I've never started at 9:05, by the way. So 8:45 tomorrow. We'll try and get going at about 9. So you guys have a good evening.
Your Honor, before you release them,
Okay.
Coach?
The last time I saw a tiger was at even.
and assessing.